My lord, the item number 2, my lord, we have filed an application seeking implement and also filed an application for getting stay. In fact, it was moved 2-3 days back. Today is fixed. In fact, my lord, our client who is next in the seniority, I have been promoted. Now, because of the order passed in the writ petition, my lord, my promotion has been stopped. So, may I pray, my lord, the matter may be taken a little later or at 2 p.m. as your lordship directs.
Well, I have some issues at home. It can be taken up after because I have some engagement.
No problem. If your lordship
After the-
permits by 12:30, we can
Yes.
ensure the matter comes. Deep learning.
Lordship, in the same matter, Lordship, state has also filed one beginning petition. That may also be called for.
Call for it. Huh?
It has not been given.
Call for it.
May it please your worship. Well, may I pray for listing of a matter for motion tomorrow?
What is the urgency?
My lord, we applied for forest guard.
Hmm.
There were 2 advertisements running through. We were within the age zone. Abandoning that, they went for a third one without including the earlier one. Now we crossed over. In terms of the OM, age relaxation, consideration is there. In absence of the consideration, I missed the bus. May I have it tomorrow?
You missed the bus.
I would miss the bus, certainly.
Catch a train then.
Unless lordship intervenes. May I pray for tomorrow?
Why tomorrow? Why not Monday?
The exams would start, and I'm told if they start, unless there's a judicial order, this would act reserved into post whatsoever, the consideration would fail. That administrative in fact was angle would come in. Therefore, I'm praying for tomorrow.
All right.
Obliged to.
Yes, please, Your Lordship. I'd like to mention 2 separate writ petitions for admission hearing. Otherwise, one is analogous matter comprising of 3 writ petitions. All are similar writ petitions relating to pay protection. May I pray any date, Your Lordship?
Put a date after 10 days.
10 days, Your Lordship. And also with regard to second writ petition, it was actually fixed for after 4 weeks. It last came up in the month of November. That also hasn't come up, Your Lordship.
That should come up in next November then.
Your Lordship, if I may pray next week, Your Lordship,
No, next week not possible. After 2 weeks.
after
May I
Highlight.
please, Your Lordship? I'd like to mention that my matter for admission hearing, writ petition. And come next.
After 2 weeks, yes.
After-
May I please your lordship, I am praying for listing of this for similar repetition lordship in the admission column.
After 2 weeks.
Okay.
May it please your lordship.
Yes.
Lordship, this matter pertains to the wherein the government has removed us without any speaking order. The petitioners were working as LBA cum typist in the advisory council for scheduled caste and backward classes. There, what has happened, Lordship? after
How
the-
many petitioners are there?
Lordship, 4 petitioners.
Okay, when were they appointed?
They were appointed by order dated 17/7/2002. Petitioner 3 and 4 were appointed LDA. 3 and
Now,
4
these appointments were pursuant to any selection process.
selection process without, and their lordship, what has fallen on the last occasion, was there any advertisement?
Yes.
There was apparently no advertisement,
No advertisement.
no advertisement. But what has happened now, lordship?
Hmm.
This court would not go into that thing because this is no more res integra. This has already been decided. Now, if at all the state wants to go, they can only file appeal. Because what has happened, lordship, the single judge has held that our appointment would not be coterminous with the advisory council. Being aggrieved, and they should be regularized. What is the single judge has held. Being aggrieved, the state went for the appeal. The appeal got dismissed, and the honorable division bench has upheld the judgment of the single judge. Now, subsequently, we went appointed. We are regularized. We were asked to join. We joined. We went for 2 days. Then contempt was filed, saying that they have not complied with the order. Then ultimately, the speaking order, which your lordship will find it annexure 4, page 45. If I may read this slowly, your lordship.
Yes.
Middle part. In pursuance of the order dated 25/5/17 in WPC number 1538/11, it is directed that the petitioner's service will be continued without disruption and they will be treated as permanent staff for the concerned advisory councils. That is, their services will not be dependent on the tenure of the vice chairman of the council and they will be treated as essential staff in the office of the vice chairman or respective council. Then subsequently, lordship, this court agreed by filing the contempt, which your lordship will find in annexure 5, page 46, the next page. Their lordship,
1 minute, 1 minute.
yes, your lordship.
Yes.
Yes, Lordship, thereafter, annexure 5 is my contempt application. There your order, Lordship will find the next page 47.
Hmm.
Here, Lordship, second part, by my learned senior friend. In compliance with the judgment and order dated so and so, Mr. So and so learned additional senior advocate government that produced an order dated 14/12/2022 of the Principal Secretary of the Government of Assam, the Tribal Affairs Plain Department. A reading of the order dated 14/12/2022 makes it discernible that the requirement of the judgment and order dated so and so has been duly complied with. So this stands closed, and ultimately, after this close, after 2 days, we have been by a verge oral order, we have been asked not to come. The only reason
Who has asked you not to come?
my application, Lordship,
Who has asked you not to
the
come?
Principal Secretary.
Is respondent number?
In husband,
Hmm. Yes.
so Lordship, my application after that,
Hmm.
that I prayed that please take me, and he has already asked his personal assistant, his secretary, to inform us that please don't come, and our passes has also got expired on December 31st, 2022, and thereafter will not be able to join. And their stand of the ultimately what has fallen out to file instructions, they have filed the affidavit. In their affidavit, they admitted one thing, which your Lordship will find, which is marked as flag A. If I'm not wrong.
Yes.
Their Lordship will find page 57, middle part. They admit to this fact. If I may read it, middle part, Lordship,
Yes.
57 page. In the instant matter, the petitioner's services are as of now not required inside the Assam Secretariat complex. And whenever there will be such a requirement, the matter will be considered following laid down norms. Now, Lordship, to my humble understanding, the rules, the Advisory Council for the Welfare of the Scheduled Caste in Assam rules, 1967. There, Lordship, one thing is very specifically mentioned, if I may read it, Lordship. The rule 5, it specifically says that there will be an office. The council shall have a secretariat staff consisting of a secretary and such other officers and staff as the governor may consider necessary to appoint. So we have been appointed by the governor. The office of the council will be located at Shillong, now Guwahati, and will form part of the tribal areas and welfare of backward classes department. So the office is now which I am working there, and they have
So presently, the petitioners are not working.
not working. They have been asked not to come, and we have not been allowed to enter the.
And where is the office?
Is inside the secretary. So that is my own place.
May I have a minute? My lord, what my friend has submitted, actually, everything is not very correct, my lord. My lord, I will again, my lord, try to, my lord, explain that. My lord, first I will go to just, my lord, I'm trying to make out my submission, my lord, page 26, my lord. Though, my lord,
Mr. Dhar, there is an order of the court, division bench upholds it. The principal secretary complies with it, their services are regularized. Now he says you can't come to the office.
no, my lord, that is what I'm coming, my lord. That is what I'm coming, my lord.
Hmm.
That is where I'm coming, my lord. My lord, I will just go to my lord.
No, you come later on. Tell us, are they being allowed to work? Are they in service?
They are in service.
They are drawing their salaries.
Exactly, my lord.
Then why aren't you letting them to come to office?
My lord, permit me only 2 minutes time, my lord.
No, are they coming or not? We want to know that.
My lord, there is no office. That is where I am coming, my lord.
Hmm.
My lord, will permit me only 2 minutes time, my lord. My lord, page 37 of this is the order of the learned single judge, my lord. The operative part, I am reading, my lord. From where this contempt has, my lord,
Hmm.
page 37, my lord. Para 17. Page 37 of the writ petition, my lord. Para 17.
Hmm.
Following the above, the petitioners are held entitled to continuation in service without disruption, as they may be treated as the permanent staff of the concerned advisory council. My lord, concerned advisory council.
In other words, the petitioner's service should not be dependent on the tenure of the vice chairman of the council. My lord, vice chairman of the council. And they be treated as essential staff in the office of the vice chairman of the respective advisory councils. It is ordered accordingly, my lord. This is, my lord. The order was, my lord, they be treated as members of the staff of the council, advisory council. This is again upheld by the Honorable Division Bench. That is in page 43, 44 is the operative part, my lord. 44. 44, the reason given by the learned single judge was that though the appointment of chairman and vice chairman of these advisory councils may be political appointment, but the post held by the supporting staff are permanent in nature, and therefore they are being in service only till the time when such chairman and vice chairman is holding the post is not just fair. It is for reason that the direction was issued to the respondents to treat them as permanent staff of the concerned council. My lord, they be treated as permanent staff of the advisory council. My lord, then contempt was filed, page 45, the next page, my lord.
I've seen it.
My lord, the third paragraph. This is the, my lord, the operative part that departments taken, my lord, this compliance note, my lord. In pursuance to the order dated such and such in writ petition of such and such, it is directed that the petitioner's service will be continued without disruption, and they will be treated as the permanent staff of the concerned advisory council. Their service will not be dependent on the tenure of vice chairman of the council, and they will be treated as essential staff in the office of the vice chairman of the respective council, my lord. So, my lord, this is the order passed by the department, my lord. Now, coming back to this, my lord. Now, I will explain, my lord, these councils, my lord, these are all political appointments. So, my lord, if after every elections, my lord, what government used to do, they used to form these councils. From 2017, my lord, no such councils has been, my lord, formed, notified, or constituted, my lord. My lord, these are political decisions, my lord, government, but still.
All right, Mr. Dhar, you've said it political. Now, whatever be the reason, there is a court order and you have complied with it.
We have complied, my lord. Now, coming back to that, my lord, what happened? I have explained this on the last occasion before the coordinated bench, my lord. My lord, order dated 3/2/23, my lord. In this, there was a query from this honorable court, my lord. Mr. Sarjan sir shall obtain instruction as to why the petitioners have not been allowed to work or be accommodated in the council's office.
Right.
My lord. Now the problem, I have the instructions, written instructions, my lord. I'm just, now I'm placing.
Yes, but you speak up what is there in it.
My lord. My lord. Now the thing is that, my lord, there is no permanent office of these councils. What, my lord, when they are constituted the chairman, this MLAs, my lord, they, my lord, of their own thing, my lord, they form an office, my lord, they will decide where the office will be. And apart from these three petitions, my lord, there is no staff. It is not that we have a secretary, they have a secretary, anything else. There is my written instruction, my lord, only them. So, my lord, that is what. Now, there is no office. So, we have, that is why, my lord, we said that you will be getting a salary until a new advisory council is constituted or notified. Without that, secretariat is a different entity.
So who will pay the salary?
Salary will be paid by the, my lord, obvious, my lord, government. What they are getting, they are receiving their salary, my lord. But still, until because advisory council is a total different entity, my lord. They advise to the government, my lord, regarding this welfare issues. That is only their thing. As of today, from 2017.
So if you are paying them the salary, you utilize the services somewhere as a temporary measure. What is the big deal about it?
My lord.
How can you allow people to draw salary and do nothing?
My lord, that part, my lord, I'm coming, my lord, but not in the secretary, because secretary is it is a different entity, my lord. What we can, my lord.
Oh, Mr. Dhar, please don't repeat again and again. We understand simple English.
My lord, my lord.
All right, there is no advisory council, but now there is a government order that they are regular employees with continuous service. Correct, uninterrupted service. So therefore, they will have to be paid their salary, other, whatever service benefits.
My lord.
So councils or no council, you have to avail their services. What is such a big thing about it? If the advisory council of office is not there, ask them to work somewhere else.
My lord, that is what they want to get into the office of the principal secretary, my lord.
No, what is your proposal? You tell us what is your proposal. Assuming that what you say is the correct position. Are they going to draw salary by sitting at home?
My lord, for that, there is a suggestion, my lord.
Hmm.
My lord will allow me 2 days time so that a formal order could be passed. What, we have some corporations,
Hmm.
SC corporations, my lord. So what we can do is, we can, until this councils are notified,
Yes.
constituted,
Hmm.
we will accommodate them there. They will remain member of this council only.
Correct.
Correct, their service condition will not change.
Hmm.
They will not become the part of the thing, but they will go there and they will attend office
Right,
there.
right. Make them work. Make them work.
That part, but not in the secretariat manner. Because the government is a different entity.
That you are entitled to. That will not interfere.
So my lord,
They cannot choose that we
Ah.
want to be here.
so my lord will
That-
indicate, my lord,
Hmm.
my lord will permit 2 days time.
Hmm.
I will try to, my lord, work out and get an order.
Lordship, if I may be allowed to rebut 2 things.
Hmm.
One, I have taken your lordship to the rules. The rules very specifically say there will be office. The office is in the secretariat. Why I say so, lordship, this is a printout I have taken out.
Mr. Mahanta, I can deal with it and reject it. In that case, you have to go in and appeal. You want that?
Lordship,
But they are saying the council office is not there. We are
lordship,
not unreasonable people. We will compel them to
but to the record, they have
secretary.
not done anything, lordship.
How are you bothered? If your service condition is not hampered with, you keep getting salary, you have to work.
Yes,
wherever
lordship,
they
I'm
want.
willing to work, but the
Well,
office is
it
there.
can be in the secretary, it could be outside the secretary. You can't choose all these things.
Because advisory council office is located inside the secretariat, lordship.
Maybe, but that council office is not there today. That's what they are saying. Are you disputing that?
2017 till today, there is no office.
Are
They
you
have not brought
disputing
on
this?
record anything disputing that there is no office, lordship. Now there is a new stand they have taken in this
Oh,
instruction.
Then
thing.
you have to go to civil court because this kind of disputes we cannot. He
Only
says
thing
no
my-
office, you say office, how are we going to? go into
I may
all
be
this?
accommodated anywhere.
Yes,
That
that
right,
is
but
the
what-
jurisprudence. We will go by the jurisprudence.
Yes, sir.
Nothing else, nothing more, nothing less. You have a right to be treated as permanent employee, receive your salary. There should not be any alteration in the service.
Very well.
Beyond that, you do not have any right, and we will not recognize that. Heard Mr. K. M. Mohantola and counsel for the writ petitioner. The basic grievance of the petitioner is that despite an order continuing them in service by treating them as permanent staff of the concerned advisory council, the petitioners have not been allowed to join their duties in the secretariat building in dispute, full stop. Mr. R. Dhar Lanet, Standing Council, WPTN BC has obtained written instruction dated 8/2/2023. A perusal of which goes to show that although the petitioners have been treated to be in service as permanent staff, yet since there is no advisory council in operation, there is no functional advisory council operating in the dispute secretariat as on date. Hence, they have not been allowed to enter the secretariat since passes are not issued since entry passes cannot be issued unless the person concerned is a serving employee on duty, full stop. Mr. Dhar, however, submits that since the petitioners are being paid their salary and have been treated to be in service, he be granted time till 15th of February 2023 to seek instruction and appraise this court as to whether, without altering the conditions of service of the petitioners, they can be assigned duty in some other establishment coming under the respond number 2, so as to serve until such time a new advisory council is formed. Full stop. The aforesaid suggestion of Mr. Dhar appears to be reasonable and deserves consideration of this court. In view of the above, let this writ petition be listed again on 15 to
Can
2016.
be 16 ballots. Once 15 I won't be, my lord.
Acha, 16 good, 16 to 2023. So as to enable Mr. Dhar to obtain instruction in the matter. Full stop. It is made clear that pendency of these writ petition shall not be a bar for the authorities to take appropriate decision in the matter in the light of the observations made herein above. A copy of this order be furnished to Mr. Dhar during the course of the day. Yes. Let us solve the problem. Tell your officers, solve the problem. What is the point in creating more stalemate?
No, my lord.
Then,
That is what I advise.
yes, tell them that you are paying him salary, put them anywhere. If you don't want, give them to us. We'll use it in the High Court. You can't let people draw salary and do nothing. Yes, next.
Supplementary list for motion items will be served.
Hmm.
My lord, basically, we have.
Notice has to go. Nothing can be done without notice.
My lord, the fact here is that, my lord,
What is the interim order you want today?
my lord, not to repatriate them, my lord.
That order cannot be passed without instruction. Repatriation is not a fundamental right. or legal
Definitely,
right.
my lord. I'm
Huh?
agree, definitely, but there is a policy enacted by this BSF itself, my lord. There is.
We have to see whether they are doing it in violation of your right.
Yes, my lord.
Because if the policy, we will not interfere with the policy,
My lord.
but if implementation of the policy
My lord,
turns out to be infringing the right,
my lord,
then we'll interfere even if there is a policy.
my lord,
But for that, she has to come up with a response.
my lord.
And that cannot happen unless notice is issued. So
Definitely.
you please take your seat and let us pass
My
the order,
Only my.
which is in the interest of your client.
My lord, definitely.
Or if you want to argue, then you argue. After that, I'll pass. the-
My lord, only my humble submission is that there is no less possibility if my lord, they will on repatriate. There is less opportunity of my lord reverse.
That is your imagination. You are telling us that even if the court passes an order, they will not be brought back. That is matter of your imagination.
All
We
your
don't comment.
logic may issue.
Heard Mr. BK Das, learned counsel for the petitioner. Peruse the averments made in the writ petition. The petitioner is basically aggrieved with the proposed move of repatriation by contending that such a move is contrary to the policy as well as the legal rights of the petitioner involved in the matter. First of Ms. R. Devi Lana CGC appearing to the respondents prays for 3 weeks' time to obtain instruction in the matter. NOM 3 weeks. Since Ms. Devi has accepted notice for all the respondents, no formal notice, extra copies. Heard on the prayer of interim relief, this said prayer will be considered on the returnable date. The respondents to bring their stand on record by filing affidavit. In the meantime, full stop. It is also made clear that any decision taken in the matter during the pendency of this writ petition shall be subject to further orders that may be passed in this proceeding. Same order in the other matter, Kali list along with
My lord.
item
Same.
27. All right,
All right.
you can't get anything more than that
Yes,
now.
definitely.
Wait, have patience.
Definitely.
Yes,
Oblige.
and look up those judgments,
My lord.
if there is one,
My lord.
that courts will not get into policy matters.
My lord.
But a policy cannot be violative of fundamental or legal right of anyone. If that happens, then the court can look into the violation,
My lord.
even if not the policy.
My lord.
Come prepared with that.
My lord.
Yes.
Oblige.
Order stayed against item 29.
Mr. Saika, there is a little request for little accommodation because some stay vacating application.
Not in this matter.
Not,
Not in
this
this
another
matter.
one.
Acha,
That
that
is
is-
another one.
Okay.
Actually, I prepared for that case, but this is the
Acha, you are in both.
I am in both.
My lord, the matter may kindly pass over timing, my lord, but
Oh, that is causing difficulty. Every time this case is coming.
after some time, my lord, he's on legs.
Hmm?
My
Why,
senior is on legs, my lord.
Mr. Chaudhary?
Yes, my lord.
When is he not on legs? He is always on legs. Huh? Now the judges will have to be on legs to catch up. This is the catch up rule, huh?
Catch up.
What to do? What to do,
Maybe,
Mr. Shekhar?
The other matter is fixed at 12:30.
Hmm.
So after that, it may be.
All right.
Yes, I am obliged. And so
For admission, item 3.
Mr. Saikia, sorry to call you back. You know, it is to, I mean, this is something I don't mind sharing in the open court. It is for these reasons that the High Court is contemplating to come up with some IT infrastructure, including the ones where the councils get the option to choose their time and date of fixing matters on their own without the intervention of the court. Right? And only those cases which are contested, the councils can come to the court. Otherwise, they need not even come to the court. Why should a lawyer come to court every day for service report not there? This case again after 2 weeks, affidavit not filed. It doesn't make any sense. These are things people should be able to do without physical presence. Right. So if you do that, you will see around 8 to 10 matters can be listed in the court every day, and we can do it. Other cases, it is not necessary for the busy councils to come. So we are working on all these things. Maybe very soon we'll discuss with the bar members, seek their suggestions, trying to make life in the bar easier and more productive.
That will be very welcome.
Yes, and these are one of the things.
Lots.
You can actually fix your time. Through a software, you can fix that. I want to do this case at 12:30. Both sides agrees, no dispute. It will be automatically, it will pop up at 12:30, something like that. I just thought
Yes.
because of this
It will be very innovative and it will be very effective.
and many other things are being
Yes.
worked out. All right, thank you.
Deeply.
Item 3.
Maybe not. My lord, this case, it rests on a very short campus, my lord. It relates to, my lord, a particular training, which is known as, my lord, the Recorders Training Certificate Class Course, my lord. And this is necessary for selection and appointment, my lord, to the post of Lat Mandal. And this particular training is conducted, my lord, by Assam Survey and Settlement Training Center at Dokhin Gaon. Now, for the purpose of, my lord, conducting this training, and my lord, a rule was, my lord, framed by the government way back in 1992, making it effective from 88. And this is known as, my lord, the Assam Survey and Settlement Training Center Rules 1992. Now, my lord, what I find that this may not be a statutory rule, because perhaps this is not framed under any statute, my lord. And more or less, it can be said, my lord, to be an administrative instruction. But nonetheless, my lord, this particular rule is followed for the purpose of, my lord, training. Now, my lord, what has happened in this case, in terms of the rule, my lord, more particularly, my lord, Rule 20, my lord, the Director of Land Records is required, my lord, to seek the vacancy position in respect of, my lord, the Lat Mandals, and thereby, my lord, it will invite applications, my lord, from the candidates for the purpose of the training. And, my lord, if I take your lordships, my lord, to the relevant part of the rule, this is, my lord, relevant for the present purpose. This is, my lord, at page 61, my lord, the relevant extract, my lord, is part of the affidavit in opposition, my lord, filed by the, my lord, Director of Land Records. Page 61, Annexure 1 of the affidavit in opposition, my lord. And this is Rule 20, if your lordship has got it, my lord.
Which page you are referring to?
Page 61, my lord, of the affidavit in opposition.
Yes.
This, my lord, Rule 20 is relevant. This rule, my lord, is known as, I have already referred to, Assam Survey and Settlement Training Center Rules 1992. It reads as follows, my lord. For admission to, in each course, the director, that is the Director of Land Records, my lord, will invite application from intending candidates preferably by the middle of June each year, before final selection is made for admission to the course, the director will obtain a statement from each district in regard to the following. My lord, we are at least concerned with 1 and 2. The lots, that is the my lord, lot mandal, lots which are vacant or likely to fall vacant within the next 3 years. So this vacancy, my lord, in respect of the lot mandals, has a reasonable nexus in respect of the select list, my lord, which will be prepared for the purpose of training, my lord. Accordingly, my lord, the select list would be prepared having regard to the vacancy, my lord, in respect of the lot mandals. And those persons will be trained, my lord, in respect of the certificate course, and thereafter, my lord, the selection and appointment shall be considered.
Yes.
Thereafter, my lord, having regard to this particular rule, my lord, application was invited, advertisement was issued, my lord, and it comprises of written, my lord, and viva voce. My lord, after this, my lord, written and viva voce, the petitioners 1 and 2, they got to be selected. A list of, my lord, 39 candidates, select list was prepared. Thereafter, my lord, 20 candidates were shortlisted for the purpose of training. Now, my lord, my submission is, have the select list, have the, my lord, merit list from the 39 candidates would have been in consonance with Rule 20, that is of 28 numbers. The present 2 petitioners would have been fit in, my lord. Now, we came before this honorable court saying that, firstly, my lord, the select list suffers, my lord, from the vice of arbitrariness, because reservation policy was applied in such a manner that the persons securing highest marks, they were, my lord, deprived of. 70% reservation policy was applied. And persons, my lord, securing much lesser marks than me, petitioner 1 and 2, they were allowed, my lord, allowed to have the
So
training.
what is the date of the list? Select list.
Yes.
What is the date?
Yes, my lord, I'm coming to that. I have understood your lordship's query, because by this time also, my lord, they are sending the batches. I'll come to that, my lord. The
No,
training
but-
is going on.
But you will come, but why don't you come?
Yes, yes.
What is the date?
Yes, the date is, my lord, 24/9/21.
And it is valid for how long?
My lord, this is a course of 6 months. Now your lordship will see, my lord, in my rejoinder affidavit, at page 51. This is, my lord, the letter 23 August 22.
So, Mr. Talukdar,
Madam.
why don't you just briefly respond to 1 or 2 queries?
My lord,
After that, you are free to argue.
my lord.
I will hear you, no problem.
I'll definitely argue.
But don't say that I'll answer the query later.
No,
Now
no,
let
no,
me
no,
say.
instantly I'll come.
You see, your client's name did not find place in the select list, whatever.
They
list.
find place in the select list.
Huh?
My lord, their names find place in the select list. There is a select list. They say, my lord, what the director says, a select list of 39 candidates were prepared.
Where is that? Where is that?
Yes,
list?
yes. Your lordship will directly come to this one. That is why I am saying, my lord, we are part of the select list, my lord.
Where is it?
Yes, if your lordship comes to page 57. My lord, this is there, my lord, stand in the affidavit.
Page
Para-
50.
57, page 57.
Hmm.
Para 5, your lordship will see this, my lord, the bottom line. The deponent further states that the merit list submitted by the Deputy Commissioner Karimganj, white number so and so, where 39 candidates were selected by the Deputy Commissioner against the vacancy of 22 numbers. So your lordship will see the
No, but
list-
where is that list?
yes, the list at page, my lord, 77 of the same affidavit. Your lordship will see page 77 is a list of 20 candidates. And page 78, it's a list of 19 candidates. 20 plus 19, my lord, is a 39. This is the merit list.
Just a minute.
Select
just a
list, my
minute.
lord. 77, 20 candidates, 78.
So where
19.
are the names of your clients?
Yes, your lordship will find at, my lord, page 78, that is at serial number 8, Rajat Goswami. He secured 88.33. My lord, this case has become virtually infructuous because by virtue of the interim order, he has already got the relief. He was sent to training. But there is an interim order of the Honorable Court. Now, virtually, I am, my lord, arguing for serial number 13, Deepak Majumdar. He got, Lordship will see, he got 84,
Dipankar Majumdar, is it?
Deepankar Majumdar, my lord. 84.33. He got these marks.
So that is the only live issue here. Dipankar Majumdar.
Deepankar Majumdar.
Everybody else is,
Yes.
all right. Now, these courses are going on.
These courses, your lordship, which courses are going on? My lord,
Mr.
I have-
Handick, he wants to undergo a training 6 weeks. It's all enhancement of knowledge. What is the?
Lordship, my lord, that the seat of this, my lord, got training. There is a limited seat, Lordship. Lordship, my
You
lord.
can accommodate one.
Lordship.
We'll close this matter. Don't let this court write a long judgment on this. You see, somebody wants to be trained. This is good. It enhances the resources of the state. Why don't you give him a,
Lordship, my lord,
without going into the merits of his claims and counterclaims, allow him to appear, and this is not going to create a precedence. We'll make it very
Yes,
clear.
sir.
What is the
Yes.
big deal about it? Don't make the courts
My
write
lord, that-
judgments every time.
that
We have to
course-
write a 30-page
the
judgment.
course already been started, my lord.
Then in the next course,
Next course, my lord, again, my lord, it will be, my lord, that.
No, my lord, will see. My lord, this
That
is
will
not
be
correct.
published, my lord. After selection, my lord, they will, my lord, allow to, my lord, that take admission in the, my lord, RCG training, next session.
when is the next session?
Next session, my lord, it will be, my lord, May, June. or
See, he
July.
is not asking for a job.
Yes, my lord.
That
All
is
he is
true,
asking that he wants to be, trained in that particular course. Is it a bad thing to ask to be trained? I mean, all right, you have done some exercise. We have to go into whether it is. But if we go into it and find, then we'll set aside the entire list.
Lordship.
Then everything will go away. Because you see, things are not spick and span always. Do you want to go into that? If you want to go into that, we'll hear,
Yes, I'm ready to
we'll hear
argue.
the whole thing. But if we find something is wrong, we'll set aside everything, including the certificate course given. Is that what you want to risk?
Lordship, my lord, that it is already been started long back, Lordship.
Started when?
My lord,
My lord, page 54, your lordship will see.
Started when?
6 November 22. 6th of November 22, 2 months back, my lord. Two,
So
3 months back.
then how can you?
Next batch, again, my lord, they can send next batch, my lord.
No, my lord.
He's saying on, my lord, in the
that
month
is
of
not, my
June.
lord. Those who are selected, my lord, that two bases, they have been, my lord, taken admission for the, my lord, that next session. So one is already been over. Next session, we already been taken, my lord, admission 6 months before Lordship. Now those who are, my lord, even they are allowed to, my lord, that take training in the, my lord, next session, Lordship. They are
So
this already
allow him to
complete.
join in the next session?
Already, my lord, that the list, my lord, those who are selected, my lord, their, my lord, already been completed, my lord. They are-
All right, then we'll pass a judgment.
My lord.
Yes, you are good. Mr. Handick, is it a little not unreasonable, just someone who's just trying to be trained
is-
and you are.
That
being
is
so-
then Lordship, I lift your Lordship.
My lord will see the number, my lord, secured by
I
me.
lift your Lordship.
My lord, just your lordship will kindly see.
No, can you not speak to your client? And if he wants to just take part in the training process, what is the big deal?
Lordship.
Are you paying any salary to those who have?
No, my lord.
Then
No, my lord, that my lord, some remuneration they have been given.
what remuneration? It
I
will be
think
50
Malad
rupees a
is-
day or something like that. We know what you give. Why don't you allow him to take part?
Lord, can it be taken, my lord, there's sometime, my lord, I have to take instruction, my lord, whether that's a vacancy or other.
We'll make it clear that this will not create a precedence.
Lordship.
And it is done in the facts of this case. And we are not commenting on the validity of his claim.
And Lordship, my
Show
lord.
some grace. If it was a job, some seniority claim, we would not have adopted this approach.
That is true.
All he wants to do is get trained. And he's not infringing on anybody else's right. It's not that if he comes in, somebody will have to go out. It's not that.
Lordship, then, my lord, one problem will be created, my lord, that now, my lord, that this rules has been, my lord, amended, my lord, new rules will be come. And my lord, in the new rules, my lord, the minimum qualification is graduate now. It will be.
We have already been selected. in terms of the earlier rules.
So, or if my lord that any vacancies, my lord, he can accommodate, my lord, it's to, my lord, he can be accommodated. My lord, if it is cannot be accommodated, my lord, then my lord, some problem will be.
So would you like to seek some instruction on that?
My lord, I don't have any problem. Otherwise, your lordship will get some merit, my lord.
Then we'll.
Because-
sit on it.
Yes.
I heard Mr. Esquivel of the Land Council attending for the writ petition. I also heard Mr. J. Henry, Land Standing Council, Revenue Department, Revenue and Disaster Management Department, Assam, as well as Mr. D. Bora, Land Government Advocate, Assam, attending for the official respondents. First up, the controversy involved in this writ petition is pertaining to claim of the petitioners to undergo
Petitioner number,
petitioners to undergo recorder's certificate class course training conducted by the Director of Land Records and Survey, etc., Assam. Full stop. Although there were how many petitioners?
my lord, here are two petitioners. Petitioner number 2 got the relief, my lord, by virtue of the interim order.
Two petitioners in this case, yet it is submitted at the bar that the petitioner number 2 has already got relief by virtue of the interim order passed by this court. Full stop. Therefore, what is left in this writ petition is only what is left to be considered in this writ petition is the prayer of the petitioner number 1, namely
Dipankar Majumdar.
Dipankar Majumdar, so as to allow him to take part in the aforesaid training course. Full stop. Elaborate arguments have been advanced by Learned Counsel for both the parties in support of their respective claims and counterclaims. Full stop. However, since the basic relief sought in this proceeding is only to the extent that one of the petitioners wants to participate in the aforesaid basic certificate course, which is apparently held every 6 months. This court had posed a question as to whether, without going into the merits of the claims and without creating a precedence, the departmental authorities would be willing to allow the petitioner to participate in the training program.
Petitioner 1, my lord.
Petitioner number 1 in the training program. The aforesaid proposition has emerged primarily on account of the fact that the petitioner is not seeking any employment, but is merely seeking to participate in a training course. Full stop. It cannot be denied that addition to the number of trained manpower would be a development in the human resources of the state. And if the petitioner is accommodated, he would not infringe upon the rights of any other candidate. Full stop. On the request of Mr. Hendick, let this matter be listed again on 21st of February 2022 as a fixed item,
Obliged.
so as to enable him to obtain instruction. Copy of the order will be furnished to Mr. J.
Highly obliged.
Deeply.
Item 4.
May it please your lordship, my lord, I am not well. So,
You are not well.
yeah.
Get well soon. How much time? 2 weeks. On the prayer of learned counsel for the petitioner, this matter stands
Lordship, it is a 2015 matter.
adjourned for 2 weeks. Ms. R. Devi, learned CGC is present. Registered to list this case again after 2 weeks on a fixed date for admission hearing. Yes.
My lord, my lord.
Item 5.
May I please, Lordship? So this matter pertains to the cancellation of appointment. my lord.
Cancellation of appointment.
We are selected and appointed as BSF constable tradesman. Therefore, my appointment was cancelled. And last occasion, my lord, this court ordered to take decision and one other decision. That's regard of the honorable High Court order, previous order, it is 23, my lord. But they pass in some order, my lord. That will be, my lord.
Earlier order has been passed, lordship, since the honorable court has directed to pass another order. This fact is same, lordship. And his case.
Is it a covered
rejected,
case?
Lordship.
Covered case?
No, lordship. His selection and offer of appointment was cancelled on the ground that the reservation policy was not, the policy regarding the lordship, the reserved category candidates who do not lordship, taken any relaxation, they will be considered on merit against the unreserved candidate.
So he's a reserved category candidate.
These are reserved candidate, category candidates, lordship, but they were not considered against unreserved category on merit. Therefore, some wrong has been done in the earlier merit list. So it was accordingly rejected, lordship, and fresh merit list was prepared. In the fresh merit list, they have not got.
No, but they were already appointed.
Not appointed, lordship, they were issued offer of appointment. They were, appointment order was issued, but not appointed. Before appointment, they were, their,
So some other case has been already decided. Some other-
earlier they have approached this honorable court, lordship,
Hmm.
and honorable court has directed to pass appropriate order in this case. So order was passed that they are not eligible for appointment because they are not in the merit list. Against this, they again.
And
approach
let's
this
come to the,
honorable
my
court.
lord, page
So
23.
what is
my
the
lord-
principle? What is the principle? Talk about the legal principle.
My lord. My
What
lord,
is it? Let us take it that your clients do not make it in terms of merit well compared with the general category candidates. And they are also not entitled to get the benefit of reserve category. This is their stand. Is that your stand?
Lordship.
My lord,
Now, even if an offer is made, are they bound to comply with it? Can the court say that no, even if it is a mistake, you must appoint them? Is that the law?
my lord, actually what happened, my lord? The discrepancy was found regarding, my lord, OBC candidate. But
Hmm.
we are in, my lord, SC candidate.
Hmm.
One of them, my lord, general candidate.
Hmm.
What happened with, my lord, our selection, my lord? There is issue regarding, my lord, OBC candidate.
No, they have all come together in the same writ petition.
My lord.
Same writ
Same
petition.
rate.
Lordship,
That's
this
what we
is-
have been telling again and again. If they are not similarly situated, then no relief will be granted. You can't find it common writ petition. There is something called misjoinder of parties. You have heard about it?
Lordship, this is not again regarding the ST or OBC candidates. With the adjustment of some OBC candidate with the general category, these ST candidates were lordship adjusted again ST category and they were not in the merit. Therefore, they were out. And OBC candidates were in the with the lordship general category. Some ST candidates are.
Yes, Mr. Burman. In this case, Mr. Jyotirmoy Rai appears.
And your.
This before any other bench without me.
My lord.
Obliged.
Deeply obliged.
Item 6.
Lordship, I have been served with a copy of affidavit of opposition yesterday only. So I need some time to give a reply.
Affidavit filed by whom?
Lordship,
As per numbers?
one lordship.
Lordship, one.
Mr. D.N. Bhattacharya, and counsel for the petitioner submits that a copy of the counter affidavit filed by the respondent number 1 has been served upon him only yesterday, and therefore 2 weeks' time be granted to obtain instruction. Prayer allowed. Mr. A. Talukdar, learned government advocate Assam is present on behalf of the state. This the matter accordingly.
Deeply obliged, lordship.
Item 7. 7 and 8.
Lord, in this case, Lord, there is an order passed by this honorable court on 16/12. Now, you just comply with that order and nothing else. The award was passed in the year 2020 to 2000.
Yes, Mr. Sai.
Lord, one thing, Lord. So for the petition first petition is concerned, two workmen were involved, both of them expired. Their wife approached before this honorable court. Their only nuance is that they would like to have, they would like to have their back wages till the date of his death. Death gratuity amount, this much. And so for the second petition is concerned, the person concerned also attained superannuation. So he is not entitled to be reinstated. See, he is only entitled to have this gratuity and the back wages, if any. And then I have been instructed by my client that they will be happy if their medical treatment as provided is provided to them. So I also intimated my senior counsel on several occasions to have to negotiate a settlement, but nothing has been done.
My lord, in fact, my lord, what happened, as per us, my lord, we are not liable to pay, my lord, the amount.
That is their condition.
That is, but because even if it is any, my lord, they have to alternative for my lord, as Supreme Court observed, 33C2. My lord, your losses may just, my lord.
Where is the order of the Supreme Court?
Yes. My lord,
Is it on record? Order of the-
not that, my lord. 33C2 is provided.
No. In this case, the order of the High Court was challenged in the Supreme Court by the ONGC.
That has gone, my lord. That is not.
Only that is what is going to matter, nothing else.
No, now the thing is this, my lord, if any amount is liable to be paid under any award, my lord, that they have to approach the industrial tribunal under section 33C2.
No, Mr. Saiwala, where is the order of the Supreme Court in this proceeding?
In this proceeding. In this proceeding, my lord, the SLP has been dismissed. That's appeal. Page 47. Page 47.
Page 47.
That Supreme Court has demanded back the matter. High Court has upheld the award.
Subsequently, your last order will follow page 65. Ultimate order. This is the point they are raising on several occasions in defiant court. I don't understand why this point is being cropped up. 33C2 will come up when there is a disputed amount.
Yes, not a dispute is there.
I think there's some contempt proceedings to be drawn, otherwise we will not get it. Let them come. Let us hear it from the principal
Just a
employee.
minute, just a minute.
Election is better.
Which page is the judgment dated 21/5/2004, passed by the single judge?
21/7.
21/5/2004. Single judge's order.
Oh, at page 40.
Page,
The upper, it starts from page 24. And the operating portion is page 40. And this judgment was initially set aside. Thereafter, we went to the Supreme Court. Supreme Court affirmed this judgment. And in terms of this judgment, the division bench passed an award in our favor. And they again, it is held in the Supreme Court dismissed it.
this was set aside by which order?
That is page 45.
Page 45.
Which starts at page 41. Operative portion is page 45.
All right.
Then we went to the Supreme Court. Supreme Court remanded it back. That your lordship will find it at page 64. Relevant, it starts from page 51. Elaborate order.
Yes. So now it is a question of implementation of the awards.
Award, nothing else.
So how do you implement award?
They have to pay our back wages.
No, no,
Now,
supposing they-
what they want to say.
Hmm.
They want to say that, yes, we don't know what is the back wage, amount of back wage. It is up to the labor code to determine the amount of back wage. So what they want to say, you approach there. They will certify
No,
the
no,
amount.
that is, you are the petitioner. What is the relief you want?
I want that it should be implemented because
Hmm.
for the petitioners are concerned, their husband expired during the pendency of this proceeding. So till the date of their death, they are entitled to have their back wages. Even if we assume that the back wages is a disputed question, but they are entitled to have their gratuity amount. Gratuity amount is not at all disputed amount. That was not paid. They are entitled to have the other medical benefits. We have filed an interim application.
So
Simply,
does the award mention what are the benefits they will be
no,
entitled to?
no. Backward award mentioned that you regularize them within a period of 6 months.
Hmm.
That was passed in the year 2000. And if you cannot regularize them within a certain period, you pay the regular pay. And that was not implemented. They preferred read application. Read application was dismissed. Then they preferred read appeal. Read appeal was not allowed. Read appeal, by this read appeal order, they have sent it back to the industrial tribunal.
So what is the date of award applicable in the first writ petition and the one applicable in the second writ petition?
Date of award.
Yes.
Date of award is 18/12/2020. 2000. That.
This is applicable in the first writ petition.
Yes.
Petitioners in the first writ petition.
That is the award. That is, this award has been affirmed by the Supreme Court.
How many awards are there?
Only one award. This is the award.
One.
This is the award. This award was challenged by them.
Hmm.
This court dismissed this petition. Then they preferred read appeal. Read appeal was not allowed, but by read appeal, they have sent it back to the labor court, the industrial tribunal for re-adjudication. We approached before the Supreme Court. Supreme Court did not did not agree with the order passed by the division bench. They again sent it back to the division bench for their consideration. Division bench considered it, and division bench affirmed the order passed by the learned single judge, all as on 21/5/2004. That order was passed in the year 2019 after 15 years. Then again, they preferred it a Supreme Court. Supreme Court again dismissed it. Now we have come to this court for the implementation
So
of this
the
award.
first
No,
writ
we can't implement it.
First, no, we'll direct them to implement. Mr. Sahawala, you can make your argument.
Whatever the amount they.
The award has to be implemented. There is no question about it. It is attained final.
Well, it is up to them. One thing that I would like to say. Whatever, if they say that we are entitled 5 rupees, let them pay
Give
5
them
rupees.
whatever according to you. they
Yeah,
will-
according to you, let them pay. Then we shall go
We are
to.
not saying anything about the amount. But how can you now say the award cannot be implemented? That order.
So
this
if
court
they
is
say 5
definitely-
rupees, let them pay 5 rupees.
So you can take your time, but I'm disposing both the writ petitions with the direction that within 60 days, the award has to be implemented. And whatever they are entitled to, as per the award, that should be paid to them. You decide what they are entitled to. If they are dissatisfied, they will have to show that
I will come to the labor court.
they may be satisfied also.
But only thing, my lord, what I am submitting, here the calculation are there. If your lordship see, my lord, what PTC says, if that judgment, my lord.
No, no, it's a very wrong award, but it
Let
is
us
still
visit.
to be.
They got
That
this
is,
out.
that is why, my lord, I am submitting, your lordship may just see one paragraph of the judgment, my lord, 2016-9, my lord, one paragraph only.
Hmm. Yes.
My lord, para 4, second part, my lord. Your lordship may please. Quoted, my lord, it is eight,
Paragraph?
para 4.
Yes.
The second part, sub para 8.
Hmm.
The principle enunciated in the decision referred to by either side can be summed up as follows. Whenever a workman is entitled to receive from his employer any money or any benefit which is capable of being computed in terms of money, which he is entitled to receive from his employer and is denied of such benefit, can approach the labor court under section 33C2 of the Act. The benefit sought to be enforced under section 33C2 of the Act is necessarily a pre-existing benefit, one flowing from pre-existing right. The difference between a pre-existing right or benefit on one hand and the right or benefit which is considered just and fair on the other hand is vital. The former falls within the jurisdiction of the labor court exercising powers under section 33C2 of the Act, while the latter does not. It cannot be spelled out from the award in the present case that such a right or benefit had accrued to the workman as a specific question of relief granted is confined only to reinstatement without stating anything more as to back wages. Hence, the relief must be deemed to have been denied for what is claimed but not granted necessarily against denial in judicial or quasi-judicial proceeding. Further, when a question arises as to adjudication of a claim for back wages or relevant circumstances which you have to run into are to be considered in judicial manner. Therefore, the appropriate forum when such question of back wages would be decided is only in a proceeding to whom reference under section 10 of the Act is made. To state that merely upon reinstatement, workman would be entitled to, under the terms of the award, to all his arrears, pay and allowances would be incorrect, because several factors will have to be considered as stated earlier to find out whether workman is entitled to back wages at all and to what extent. Therefore, we are of the view that High Court ought not to have presumed that the award of labor court for grant of back wages is implied in the relief of reinstatement or that the award of reinstatement itself is conferred the right to claim back wages. My lord,
Mr. Saiwala,
Yes.
I will hear you
Yes.
and I will also record you.
My lord,
But you can very well appreciate
yes,
that this is not an appeal against the Supreme Court order.
my lord,
So obviously we will not accept it. Obviously,
Yes.
it's up to you how much you want to argue.
yes,
There is no option now, but the ONGC has to implement the award. That is the order I am going to pass. There is no option because the issues cannot be reopened. Within 60 days, payments have to be made, failing which 9% interest from the date of this order till realization. They have to be paid. ONGC can't be. What about the other employees? There are 22 of them. What happened to
No,
them?
they are working.
They are working.
Some of them, all of them.
So in the first,
Because of the expiry of these 2 workmen, they could not be.
so
released.
they have got the relief.
No, they have not full legal job, but they are working there. That is their problem. They are working, they are getting salary. But
All
they are,
right, so in WBC 8802, they are the widows of the 2 employees.
yes,
And in WPC number, other WPC is a retired employee.
retired.
All right. So would you like to really argue anything or
my lord, only thing that 33.
we will not ask them to
No,
go.
no, only my argument maybe just noted down, my lord, no.
That will do. That will. do. 33, see, what the judgment you have cited is a statement on law.
Yes.
But when orders are passed specifically on facts of the case, we can't say that Supreme Court was wrong.
Well.
And was that point raised before the Supreme Court? Then that was not raised. All right, take down heard Mr. Dasgupta, learned senior counsel assisted by Ms. Vidas, learned counsel appearing for the petitioners in both these petitions. We have also heard Mr. G. N. Sahal, learned senior counsel. I have also heard Mr. G. N. Sahal, learned senior counsel assisted by Mr. B. K. Das, appearing for the ONGC authorities. Full stop. Since both these writ petition raises common question of law and facts, hence these are being disposed of by this common order. Full stop. The brief factual background of this case is that the writ petitioners in WPC number 8802 of 2019 are the two widows of two workmen employed on contractual basis under the ONGC. Full stop. Writ petitioner in WPC number 9114 of 2019 is also another workman employed on contractual basis under the ONGC, but he has retired from service. Full stop. Earlier, by notification dated 14/6/1999, issued under Section 10 of the Industrial Dispute Act 1947, the following question was referred to the Industrial Tribunal at Guwahati for adjudication within courts. Page 26 of you will get. Full stop.
Here only we are concerned with the annexure A, not annexure B. Though these two questions. Yeah,
No, in page 26 of the order of the learned single judge, the
yes.
reference is quoted. That is the reference.
Oh, just for your clarification.
After hearing both the sides and on consideration of materials available on record, the learned Industrial Tribunal at Guwahati had answered the reference in favor of the workmen by issuing the award date 18/12/2000. Is the award on record?
Yes, yes.
Which page? Which page?
At page 9, relevant page is 23.
The relevant observations made in the award dated 18/12/2000 is reproduced herein below for ready reference. You will get it in
Page 23.
Page 23. Page 23, double tick to double tick. Full stop. Be it mentioned herein that in both these present writ petitions, the present writ petitions, we are concerned with annexures A
A of the reference.
of the reference, since annexure B pertains to, what is annexure B?
That is equal pay for equal wage. Learned single judge has
Annexure B pertains to,
annexure B.
some other category of workmen, full stop. Aggrieved by the award dated 18/12/2000, passed by the Industrial Tribunal, Guwahati at Assam in reference number 12 bracket C bracket close of 1999. The respondents bracket ONGC had preferred two writ petitions numbered and registered as WPC number 8376 of 2001 and WPC number 8369 of 2001. First up. First up. Both these writ petitions were disposed of by the learned single judge by judgment dated 21/5/2004, dismissing the writ petitions. Full stop. Aggrieved thereby, the ONGC had preferred writ appeal number 226/2004 before this court, which was allowed by order dated writ appeal number 266 of 2004 and 267 of 2004, which were allowed by the division bench by the order dated 02/02/2012 by setting aside the order of the learned single judge as well as the impugned award. Full stop. Aggrieved thereby, the workmen had preferred a special leave petition bracket SLP number 23494/2012 before the Supreme Court. Full stop. By the order dated 3/4/2018, the special leave petition was allowed by the Honorable Supreme Court, and the matter was remanded back to the division bench of the High Court, of this High Court, for a fresh decision. Accordingly, the matter was heard by the division bench, and by judgment dated 7/1/2019, both the writ appeals, is it? Bearing number WA266/2004 and WA267 of 2004 were dismissed by affirming the impugned award as well as the order of the learned single judge. Full stop. Aggrieved thereby, the ONGC have approached the Honorable Supreme Court by filing special leave petition bracket civil, diary number 14640 of 2019, which was dismissed by order dated 3/5/2019. Full stop. After the dismissal of the SLP, it was evident that the award dated 18/12/2000 had attained finality in the eye of law and therefore was required to be implemented by the ONGC. Full stop. However, when no such action was taken by the ONGC to implement the award and give the financial benefits to the writ petitioners hearing, these two writ petitions have been filed seeking a writ of mandamus upon the respondents to calculate the benefits ensuing on the petitioners under the award dated 18/12/2000 and release the amount. Full stop. Next para. Mr. Dasgupta, learned senior counsel for the petitioners, submits that the award dated 18/12/2000 is has elaborately dealt with all the contentious issues and thereafter answered the reference in favor of the workmen. First step. After the challenge made to the award has been declined by as many as 3 forums, namely the learned single judge as well as division bench of this High Court and the Honorable Supreme Court of India, there is no scope for the ONGC authorities to deny the relief to the petitioner. Full stop. As such, this is a fit case where a writ of mandamus would lie. Full stop. Mr. Sahewala, learned senior counsel for the respondents, on the other hand, submits that the award dated 18/12/2000, even if the same is held to have attained finality in the eye of law, does not spell out the financial benefits, including the back wages, etc., that would be payable to the workmen. And therefore, unless the petitioners approach the labor code under section 33 dash capital C bracket, then bracket 2, 33 dash C bracket numerical 2, bracket close of the, this is which act?
Industrial Dispute Act.
Huh?
Industrial
Of
Dispute
the
Act
Industrial Dispute Act.
1947.
No payment can be made under the award, full stop. On such ground, Mr. Sahiwala has prayed for dismissal of the writ petition, full stop. I have considered the submissions made by learned counsel for both the sides and have also gone through the materials available on record. As noted above, the award dated 18/12 to under the award dated 18/12/2000, some benefits clearly ensued upon the workmen in annexure A and annexure A and B, full stop. There is no dispute about the fact that the claim of the writ petitioners in both these petitions pertains to the category of employees listed in annexure A. Full stop. Huh? Annexure A of the reference, full stop. Although there were a number of workmen who were entitled to benefit under the award, yet it is only the deceased husbands of the two petitioners in WPC number 8802 of 2019, as well as the writ petitioner in WPC number 944 of 2019, who are presently not working, full stop. The remaining workmen coming within the purview of the award dated 18/12/2000 are still working under the ONGC. Full stop.
Petition number 2 is concerned, he is retired employment. Next petition.
That's outside, I mentioned. Full stop. Therefore, the only question that would now arise is as to whether there is any scope for the ONGC to deny the fruits of the award dated 18/12/2000 to the writ petitioners at this distant point of time by merely taking some technical plea. And if not, what direction can be issued to the authorities in the facts and circumstances of the case, full stop. The answer can deny the fruits of the award. Less part is not required. Due to the facts and circumstances of the case as noticed above, the answer of the said question obviously has to be in the negative, full stop. Insofar as the plea raised by Mr. Sahiwala regarding requirement for approaching the industrial tribunal under section 33-C bracket 2 of the Act, it is noticeable hearing that no such plea was ever raised by the ONGCL either before the High Court or the Supreme Court, full stop. Therefore, at this point of time, the respondents cannot be permitted to nullify the award by taking such technical plea, full stop. It is no doubt correct that in the decision relied upon by Mr. Sahiwala, rendered in the case of Union of India and another versus Kankuben bracket dead bracket close by Ehlers and others, reported in 2006 bracket close 9 SCC 292. The Honorable Supreme Court has observed that the money that the workman is entitled to receive as benefits must approach the labor court under section 33C bracket 2 of the Act, full stop. However, the aforesaid observations made by the Honorable Supreme Court was in the fact situation of that case. In the present case, since the ONGCL had never raised any question before any forum as regards the entitlement of the petitioners, and considering the specific language employed in the impugned award, it must be understood that the ONGC authorities were also clear about the liability, about their liability under the award, full stop. Therefore, the technical plea raised by Mr. Sahewala, comma, in the opinion of this court, comma, cannot be entertained at this point of time, full stop. Having held as above, the only question that now would survive is as to the amount that would be payable to the petitioner under the award dated 18/12/2000, full stop.
And the other medical benefits they are entitled.
Mr. Dasgupta has also submitted that his clients would also be entitled to medical benefits as is applicable to similarly situated employees. Full stop.
That is very excellent.
Taking note of the aforesaid submission of Mr. Dasgupta, both these writ petitions are being disposed of with a direction upon the respondents to compute the benefits flowing, the monetary benefits payable to the petitioners in both these writ petitions that are flowing from the award dated 18/12/2000, full stop. On such computation, the amount be released in favor of the petitioners, full stop. The aforesaid exercise be carried out within a period of 60 days from the date of receipt.
3 months, my lord.
90 days from the date of receipt of a certified copy of the order. It is made clear that if the order of this court is not complied with within the time frame as noted above, then in that event, over and above the consequences that may ensue under the law upon the respondents, they would also be liable to pay interest at the rate of 9% per annum on the amount that is found to be due and payable under the award dated 18/12/2000, calculated with effect from the date of this order till realization. Writ petition stands closed.
The only thing is that so far medical issues let it be made clear.
So I've
Because-
recorded your submission. I've
No,
recorded your
no, no,
submission.
they may be directed to implement if required, because sometimes.
No. Has it been given under the award?
No, that.
Then you can't get it. Now we are only concerned with the award.
No, they are actually agitated.
Then you have to make a reference. Because the
Anyway. like
track
it is.
of this order is that implement the award.
All right, that's
So
all.
nothing more can be brought in. Then we'll have to hear. Because he will say you are not entitled, the court will have to
But
hear.
because these people are very old men now, they are
No,
very
we
much older.
understand,
Anyway,
Why is the ONGC so stingy about these things? Why is it? This is the Amrit Kal, Amrit Mahotsav and all this is happening. This is the Amrit Kal. Huh? What is the fault of these people? Why is a court order required in everything? The ONGC, big officials, directors, they are big people having a big rich lifestyle. They can't do this much for the people.
they have their own hospital. also.
At least, if not, Mr. Sahil, I am not telling you anything,
Well, listen.
but you can communicate it to them.
My lord, sure.
Even if they don't give any monetary thing, they can at least say that we'll give you treatment in our hospital when you
Well,
want.
My lord.
Is this much of a gesture not expected in today's India? 20 years back, it was different. In today's India, when so much is being done,
Well,
this is a minimum gesture.
my
So
lord,
no direction, but the court has observed it.
my lord,
Please communicate it to your
Well,
clients.
my lord.
Please tell them to be a little gracious.
Sure.
A court order is not required in everything.
Taking time to file affidavit, madam, but no affidavit has been filed, madam.
I prefer some more time, madam, for filing the affidavit.
No, but you have been given time earlier.
Yes, madam.
Then,
I have to get the instruction. I've got the instruction, madam.
Huh?
I've got the instruction, madam. I'm going to be filing the affidavit. madam.
what is this matter about?
Matter regarding non-payment of family pension, madam.
You have received instruction. We'll give him last chance. How much time?
3 weeks, madam.
Madam.
Heard Mr. K.R. Patgiri, learned counsel for the writ petitioner in this batch of petitions. Also heard Mr. N.K. Devnath, learned standing counsel PNRD Department, Assam, appearing on behalf of the respondents who submits that he has just received instructions and therefore be granted 3 weeks further time to file affidavit. In view of the urgency expressed by Mr. Padgiri, prayer made by Mr. Devnath stands allowed as last chance. Registry to list this matter again after 4 weeks. List these matters again after 4 weeks for admission hearing. You are there?
Yes, for the director, for the Department of Pension. Here in one of the cases, your Lordship, item number 11, we have already submitted an instruction saying that we have not received any documentation from the pension department. So,
Mr. C.S. Hazarikal and a government advocate Assam is present on behalf of the state. We'll see what happens. Yes.
Obliged, ma'am. Obliged.
But why so much of problem with family pension?
My lord, actually, these matters are old, but earlier instructions were not available, but then I've got managed
No,
to get
but you
instruction.
please do it. Otherwise, we'll have to call the director.
Obliged.
Yes.
Please, your lordship. The petitioner has given retirement before superannuation. The petitioner ought to have retired on 28/2/2026.
Forty-two years of service.
Yes, then he was minor, canteen boy. And his service was regularized on 1985.
What is the order you want here?
Hmm?
What order you want?
Because as per my birth certificate, school certificate,
Hmm.
his age, 60 age at 28.
What is his date of birth?
Yes, his date of birth 1/3/1966.
1/3/1966.
Yes,
And when did he start working?
working start 15/12/1978. As canteen boy. Under the respondent
So
department.
12 years.
Yes. He was a minor.
He could not have been that. We can't
Yes.
take note of that.
Yes,
A minor could not have been engaged.
but respondent engaged him. But his certificate of relating to birth has not been challenged by the respondent department and duly communicated. Origin was produced. They have not accepted that.
Mr. Roy, what is all these things?
My lord,
He is wrong, but you are also wrong.
that's right. My lord, it happened like that.
Hmm.
He was initially appointed by the canteen management committee as a canteen staff in 1978. He was asked to submit his original date of birth, and he did not.
Yes, yes.
And
no.
later, pursuant to the order of the.
You know, this matter can lead to an FIR being lodged against the director
No,
of
but my
FCI.
lord, it happened like that.
Hmm.
Supreme Court has passed an order directing regularization of all these canteen workers throughout the country.
Hmm.
Then in 1985, he was regularized. Then we asked for a certificate, date of birth certificate to prepare a service book. He submitted a certificate, this present certificate,
Hmm.
which shows that at the initial entry, he was 12 years, 9 months old. Now, then we asked for the original certificate is submitted at the time of recruitment. He did not. Now, my lord, the Supreme Court has also, my lord, held that if the original entry of service is taken to be 18 years, then one can serve for 42 years if the date of retirement is 60. On that basis, my lord, we have retired him, not only him, many others. When they completed the service of 42 years. That's all, my lord. Now, the question is, if a minor, my lord, cannot be appointed
What is the age of retirement?
60 years.
60 years. So that means under the law, maximum 42 years. he could
That's
have
right,
served.
that's right. That is because
Now, he cannot work for 50 years, 12 years of age, my lord, can imagine, 12 years. He
Mr.
cannot take,
Bora, what can be done here?
my lord. Last occasion, my learned senior friend has submitted, a case has been pending before Honorable Supreme Court. That's why sometime wait. After that, that order goes and against him and in favor of the petitioner. This case was Gopal Prasad.
You cannot remain in employment in any government or semi-government organization
Yes.
beyond 42 years. That is the end of the matter. Because to do that, your employment has to be when you are a minor.
My lord,
If we accept that you are in a minor, then we have to set aside your regularization. Of course, we'll drop proceeding against, we'll ask an FIR to be lodged against them, but your regularization will go.
No, my
Think
lord,
about it, think about it. It's a very tricky matter.
but they have accepted.
On the prayer of Mr. Bora, next date, I'm going to pass an order. You better come prepared. This accepted business will not do. Whatever is the law, he cannot be treated to be in service below the age of 18 years.
There is no law, my lord. Regarding
Alright,
that.
then you argue, we'll dispose of this matter.
Actually, regarding 42
Yes,
years,
yes,
there
yes,
is no
yes,
law.
yes, you argue.
My lord, short time may be given. I
No,
don't
no, you argue, there is no law, you argue.
know. Regarding.
Have
42
the
years,
patience and grace to understand the query. Don't be arrogant.
no,
There are many things you need to know, learn. I am telling you a simple fact. Nobody can be in public employment beyond the period of 42 years. The reason is nobody can be appointed legally.
At the stage of minor.
Yes, 42 years, end of the matter. If you go deep into it, then maybe their action is wrong, but your employment will also be treated to be wrong. If somebody gets a driving license when he was 16 years old, if you go to renew it after 30 years and they find that the original license, it'll be treated as null and void. That's the law. We will go by it. That is the law. If you can argue against it, argue. Don't say things which are not relevant.
No, my submission, I at least next week matter will be fixed and clear. But they have not challenged my birth certificate. That's why.
So they have no challenge, so we'll pass order which is illegal.
And
Mr. L.K. Bora learning, this matter before any other court without me. Yes.
My sorry.
But here the petitioner has agreed that he has not been given his seniority as was given to his colleague on promotion, though they were under the same circumstances exactly.
Seniority will admit an issue.
The part of it is admitted by them.
Admitted.
But from what the facts that are on record, I should have got the seniority.
Admitting his
Record.
case.
Because of the standing order.
Hmm.
04 of 2015.
Where is it?
I have received one letter from the authority, my lord. It is self-explanatory, my lord.
Is it on record?
Not record, my
Then we will not accept things which are not on record. Do you have any standing order which supports you?
It's in the repetition, my lord. It is
Where
there in
is
the repetition.
Hmm.
My case is a little bit different from what he's trying to say, but otherwise the standing order, my lord, starts at page 19.
So, Mr. Majumdar, seniority matters will take some time unless, so you take a chance when some other day.
Any convenient day, my lord, this will be.
And why everything is being decided in admission stage? The hearing is gone now.
Let it be on the hearing, sir.
Huh?
Let it be fixed for hearing, my lord. Let it be on the hearing list. On a fixed day, we'll hear.
All right.
If
Heard
our-
Mr. R.
otherwise the case
Majumdar.
is- Right.
And counsel for the writ petitioner also heard Mr. Ekadatta, Central Government Council, Reckitt CGC appearing for the respondent. The issue involved in this writ petition pertains to dispute regarding fixation of seniority of the petitioner. Full stop. After hearing the submissions of learned counsel for both the sides, this court is of the opinion that this writ petition would call for full-length hearing. As such, admit the writ petition since the parties are represented. Any private respondent?
No, no.
Seniority dispute without private
My lord,
respondents.
because they did not give me my seniority, my promotion. They've given me my promotion. They've just refixed my seniority on a wrong date, from a wrong date.
Hmm.
The date corrected.
So if
I
it is
stand by it.
corrected, you will go above someone,
No, I would go back to my original position.
but that means you will go above somebody.
That my
No,
This court will never grant that relief unless you make them party.
There'll be some few thousands.
Huh?
I was injured in a bomb blast. I was given my promotion. They stopped it. And when they gave it to me, instead of the original place, they gave it to me from the
At
date of
least
promotion.
1,000 maybe, but at least one person to you have to inflate, who will be immediately junior to you.
I'll have it.
How will you get that relief? This will be violative of principles of
There
natural
was one
justice.
judgment of the Supreme Court, madam, which said that if the wrong is on their part
Hmm.
and the others cannot oppose to the wrong being done, then my lord, perhaps they are proper and not necessary parties. My lord,
Take your
I'll
chance.
bring on one of
List this matter for hearing in usual course in the first week of June 2023.
Obliged.
Item 15.
Can they pass over them without put it time being, madam?
Passover is not possible. We'll have it some other day. What is this matter about?
Well, this is regarding the promotion, madam. The last occasion.
What is your instruction? Was there any proceeding pending?
Lordship, there were two DPs conducted, there were two show cause notices, Lordship.
No, no, on the date
And the
on
pay
which,
slip, Lordship, which he has annexed, Lordship, it was in regard to another case. It was not the same case that the petitioner has referred, Lordship. There were two withholdment of increments, Lordship, one done by the Accountant General. I have flagged marked the pay slip, Lordship.
actually, there were two departmental
Lordship,
proceedings.
that's
Only one has been mentioned.
And the
Okay.
increment that was deducted, Lordship, that I have flagged marked, that was the increment cut by the Accountant General during his suspension period. That is the second case. And the first case is, Lordship, that is the withholdment of one increment without cumulative effect, Lordship.
So this first case,
So he has mixed up both the cases, Lordship. And in the writ petition, very cunningly, Lordship, the.
all right,
cases-
Mr. Your name, please?
Boro, madam.
Heard
On
Mr.
the-
A. Bora,
Mr.
learned counsel for the writ petitioner. Also heard Ms.
R.
R.
Bora,
Bora, learned standing counsel,
Agriculture Department.
Agriculture Department, Assam, who has obtained instruction in terms of the order dated 30/1/2023 and submits that on the date on which the DPC was held, there was another departmental proceeding being case number AGA.193/2016/182 dated 24/1/2017.
That is the first case, Lordship. This is the first case, and in this case, the speaking order that he has challenged. This is
Let
the
them file the
first case.
affidavit, madam. We
No,
have
Lordship, we
mentioned
have
that.
already for, the second case is the relevant case, Lordship.
Let them bring the
The
index.
second number.
Then, another case being case number AGA 119/2017/PT-1/144 dated 3/4/2018 was pending against the petitioner. But he says, when was the DPC held?
The DPC was held in 2021, Lordship. And after the speaking order was passed, only then the increment was withhold, Lordship. In 2018, it was the second case, Lordship, the period of suspension, the Accountant General deducted.
But
the-
the said fact does not find mention in the writ petition. Full stop. That proceeding is still pending.
That
Second,
is over, Lordship, that is over. In 2018, the suspension period, the increments was stopped by the Accountant General, and then his suspension was on duty. It was the state, the report was given, it was treated as on duty. Lordship.
Mr. Boro prays for some time to obtain further instruction in the matter. Prayer allowed. List this case again after 3 weeks. Copy of the written instruction can be
Lordship,
written. A copy of the written instruction dated 27/1/2023 be retained in the record of this case. Yes.
No problem.
Item 16.
Yes.
Lordship, may kindly peruse the last two orders of the Honorable Court.
Lordship, I have received some instruction, Lordship, and what I found, Lordship, their contention is correct, Lordship. Though it is not provided in the list, but we have done so on the basis of the views given by the personnel department and commission, Lordship, APSC. Lordship, I would like to file an extended effect, Lordship.
Then let them file, you get a,
Let it
so
come.
they are entitled to the relief.
No, they are saying that 30% posts are reserved for promotion only, not for direct recruitment. Here, what we have done, Lordship, persons who have acquired higher degree in the meantime, Lordship, we have given them within that 30% only, Lordship.
Our quota, from our quota.
Yeah, that is there.
All right, heard Miss P. Boral and counsel appearing for the writ petitioner. Writ petitioners also heard Mr. P. Nayak, Learned Standing Council, PWD Department, Assam, who submits that he has received some instructions according to which the allegations made in the writ
Lordship
petition,
kindly may not record that, Lordship.
received some instructions and therefore be granted 10 days time to place the same on record in the form of an affidavit.
2 weeks, Lordship.
2 weeks time, all right.
Date
Fair
limit,
enough.
please.
Let this writ petition be listed again on 3rd March 2023 as a fixed item. Yes.
Okay.
Item 17.
Yeah, please. Order is possible, could also be done. March 12, if they don't come, then it'll be done.
Lordship, in this matter, I am appearing for the respondent Dimahasa Autonomous Council, NCL's Autonomous Council, Lordship. Today we have filed our affidavit, Lordship. Copy has been furnished. to them.
Let the matter may be fixed on Tuesday, Lordship.
No,
Lordship, it's a.
Tuesday of April.
No.
It can't be as
No,
per your
Lordship.
choice.
Lordship, so far their calculation, the matter is for the correction.
You
of
file
the-
affidavit.
Lordship,
Lordship,
today.
I am ready to argue this case today itself, Lordship. Lord, this matter is very important for me, Lordship. Matter is for correction of date of birth, Lordship. Who should be occurred on 28th of February. So far their calculation, Lordship. And still their, Lordship, my service book has not been constructed, Lordship.
What is the urgency here?
So far, the respondent, Lordship, I will attain my age of superannuation, Lordship, on 28th of February, Lordship. And my service book is not yet to be constructed, Lordship. And as
And
per-
what is your stand?
Lordship, yes, he will return on 28th of February as per the record, relevant record which he has supplied. to the
Lordship,
Department at the
I
time
was,
of joining.
I was appointed on 30/4/2007.
And
And
just a minute. You cannot barge your way through here. I will hear you only when I want to.
I'm
So please take your seat. Take your seat. Yes. He says his service, in the service book, his date of birth has been wrongly recorded. Is that what he says?
Lordship, he
Right.
intends to say it like this, Lordship, but
So if that is made effective, then he is retiring this month. But according to him, what is the correct date of birth?
Lordship, actually, he has submitted PAN card.
Hmm.
Same PAN number, but different date of birth. With same PAN number, Lordship.
Same PAN number, how can it be? Can there be two? Where are the two PAN
Lordship,
cards?
I'm going.
Where is the original PAN card?
Original, Lordship, what happened?
The PAN number,
In my earlier PAN card, PAN number, Lordship, my date of birth was wrongly recorded, Lordship. Thereafter, as per procedure, I applied for correction before the income tax department, Lordship. It was corrected, Lordship. And it was corrected. And my initial,
When was it corrected?
Lordship, India year 2020, Lordship. And I submitted my,
It was corrected on what basis?
on the basis of birth certificate,
Where is your birth certificate?
school certificate, at page 20, Lordship. Page
Page
20.
20.
Page 20.
Hmm.
It was issued in the year, Lordship, 1989.
So what is your date of birth as per school certificate?
As per school certificate 21/1/1971,
Hmm. This was issued when?
issued on 6/10/1989. Then kindly come to the page number 21.
Hmm.
Identity card was issued by the authority, Lordship, wherein my date of birth was recorded on 28/1/1971.
Hmm. All right.
And when Lordship, while Lordship, the authority prepared the NPS registration form, Lordship, then it was recorded on 10/2/1963. Then being aware of that, Lordship, I approached the authority and I come to know that in my PAN card, my date of birth was recorded as so and so. And accordingly, Lordship, I applied for correction before the Income Tax Department, which was corrected with same PAN number by the Income Tax Department, which is a page, Lordship,
What
31.
do you have to say?
Lordship, he had submitted the application for correction of his date of birth on 28/12/21. He is returning on this month only.
So what is the problem?
Lordship, and moreover, the same day, means at the time of entry, he has produced a PAN card, Lordship. Based on the PAN card, his date of birth was recorded.
So what?
Now, again, he has produced the same PAN, with same PAN number, different date of birth.
Because it has been corrected. What is the bottom line? Tell us that.
Lordship,
Of
then I-
course, he is originally wrong projection was there, etc., etc., etc. But come to the bottom line, what is it? He says it was a mistake. Why should we not accept his contention?
Lordship, it should be, but.
All right,
May-
on Wednesday, we'll finish up this matter. Come prepared. If there is any legal bar, we'll not go into it. Otherwise, we may allow it. Heard Mr. So and counsel for the petitioner. Also heard Mr. R M Das, standing counsel. NC Hills Autonomous Council, who submits that affidavit on behalf of the department has been filed today, but the same is not on record. In view of the urgency expressed by the learned counsel for the petitioner, registry to tag the affidavit filed by the department and list this matter again on 15/2/2023 as a fixed item.
Obliged.
Timing matter for motion item 2.
Wait, please, Your Lordship. Well, this is a matter where, again, I have been downgraded. I'm the senior most, I'm the secretary in the Department of, Secretary to the Government of Assam. Well, my grievance was that without preparing the gradation list, again, not cadre wise, what they did, they made a select list which contains all the names of all the 900 officers in the Assam Civil Service. Whereas I have documents to show that in the secretarial service, they have their cadre. And in the cadre, these columns are there. Now, what has happened? Today, there are application, the Assam government, what I was expecting, my ground was that I went up in terms of the benefit given to me under the constitution. And after 25 years, when I am the top, you bring me down by applying a principle of catch-up. But today it has been confirmed by the Assam government, yes, it is the catch-up principle. If it's the catch-up principle, I can now fortify my case. First of all, there is no catch-up principle, which the Assam government will now have to show, because their OM of 96 has been withdrawn. Secondly, if the OM of 18 says the 2002 OM is no more in existence, because that gives me the right under the 78 Act. Power flows from section 5 as per Bhagwan pattern. Now, Your Lordship, I may take Your Lordship now to the OM, because
This is the motion stage.
yes, my lord, an interim protection was given because a vacancy was there in the 3 cadre of commissioners. 2 got they superseded me. Interim order was given, 1 post be kept vacant. And today, I'm told instructions were sought for the records, because I need to know about the minutes. But the minutes will give me a basis as to what went through, because now the Assam government has already filed a vacating application on my interim order, saying that another person has been brought in, but because of the interim order, they are not complying, they are complying with the court's order. My contention now is that the records be given, the minutes be, I may be furnished a copy, and I'm fully ready. This matter needs to be heard because this has got relevance with the earlier other matters. And the promotions be made provision.
It is the same principle.
Because ultimately, any matter decided will ultimately decide the OM. Because the Lordship rightly says the OM is the basis of the issue. And now the Assam government has made it clear, they have brought up the catch-up principle. And my contention is that the judgments which were referred by the learned additional advocate general is totally fallacious. Because on that day, I was waiting for the affidavit of the government. Why will I open up my cards? Today I'll open up my cards.
You have always been very smart, Mr. Das.
Obliged. Today I'll open up my card. The Supreme Court judgments which they are referring does not cover my case because you can bring in catch up on two principles. If there is an excessive and if there is in the absence of rules. And Assam, the 78 Act flows, section 5 is there. The rules are there. It's an enforceable right. Excessive is not our case. Pena silvam case.
All right, just a minute, just a minute.
Yes, yes.
So the other cases,
Yes,
whatever the law point involved there,
Yes.
will have a bearing in this case.
it will have.
Acha, so when are the other cases?
The other cases, your lordship has fixed on the 16th of March.
16th of March.
The two rooms case and the Lankasa's case, because all constitutional validity. And in fact, in my case, I have also challenged the constitutional validity. I foresee that the selection committee will take the basis of catch up.
All right,
And today I could catch up with the.
all right. So we issue notice on 15th
Yes,
and
yes.
16th.
And your lordship, a short expeditious hearing.
That is
and subject-
16th it will be heard.
Yes, that will be.
They have to file exchange your pleading.
Yes, yes. And I may be furnished a copy of the minutes because today in the affidavit says, say catch up with.
But
I was
there
waiting
is some interim order.
The interim order was that a person has already been selected in terms of the selection because another because my right had to be protected.
Hmm.
So now that part, lordship, since I'm ready for an expeditious hearing, I'm not at the interim. The thing is that expeditious hearing and my right has to be protected now.
Yes, any promotion given on the subject
Yes,
to
yes.
further orders.
Yes.
That's it. all
The
was-
interim order was that respondents are directed not to fill up the post.
No, we'll
vacant.
vacate that. We'll vacate.
The Lordship will modify it. That,
Modified.
We'll go ahead with whoever takes the post.
Promotion will be
Everything will-
subject to further.
Yes.
Yes. And I may be furnished a copy of the because now
Furnished a copy of
of the
the,
selection minutes because
In our affidavit, we'll give everything.
no, in the affidavit which just now has been filed, my mind was. Well,
No,
that
no,
I'll take it
we
from
have
the
not
court.
filed the main affidavit. We have filed a
Your
modification.
lordship
affidavit.
can always direct it. Your lordship had given in the earlier cases.
No difficulty in giving.
Yes, yes.
you want the stay to continue? Then take your seat. Yes. But Mr. D.K. Das, Learned Counsel, assisted by Mr. H. Betala, Learned Counsel appearing for the writ petitioner. Also heard Mr. D. Sekia, Learned Advocate General Assam, assisted by Mr. P. Nayak, appearing Learned Standing Counsel PWD. Is it PWD?
No.
Then
He is assisting me in this case only.
P. Nayak, Learned Counsel, appearing for the respond numbers.
The state respondent lordship.
1 to 5. 1 to 5.
Yes, Lord.
Mr. R.M. Deka, Learned Counsel has appeared on behalf of respond number. Respond number 9. Full stop. By filing this writ petition, the petitioner has entirely challenged the recommendation of the DPC made in favor of respondent number 9. There is no respondent number 9 in this petition. Mr. Deka.
File implementing.
Order DPC, recommendation of the DPC made in favor of a departmental candidate for filling up the vacant post of Commissioner and Secretary to the Government of Assam, Excise Department, is it? Commissioner and Secretary
Commissioner Secretary Lordship General, this is
to the Government of Assam.
He is now being under the Commissioner Secretary and CM Secretary. Because he was
Government of
the
Assam.
post of secretary.
The basic contention of the writ petitioner is that his seniority position has been arbitrarily downgraded so as to take him away from the zone of consideration. Full stop. According to Mr. Das, the petitioner, being a candidate belonging to the reserve category, was entitled to accelerated seniority in as much as the principle of the rule of catch up, CATCH.
Well, my contention is the catch-up was already nullified in the Constitution 85th Amendment. How could
Rule
the
of
Assam government bring
catch-up
it today?
Was already nullified
By the
by
85th.
85th Constitutional Amendment. First up, Mr. Saikia Lanet, Advocate General Assam submits that the DPC has already selected a candidate, but no order of promotion could be granted due to the interim order dated 3/2.
And he's in the
2023.
zone of consideration.
First up, according to Mr. Saikia, the petitioner was also in the zone of consideration and his case was also considered by the DPC. Under the circumstances, the interim order be vacated, as otherwise the same would adversely affect public interest. The learned AG has also submitted that a detailed affidavit would be filed, bringing on record all relevant facts in this case. Full stop. Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. R.M. Dekka, appearing for the newly imputed respondent number 9, submits that his client has been selected, and unless the interim order is modified, it would cause serious prejudice to the.
In fact, he was promoted because of this stay order, my lord. It has been
was,
kept in.
was
abeyance.
not only selected but also promoted, but due to the interim order dated 3/2/2023, the order of promotion has been kept in abeyance. Full stop. The attention of this court has also been drawn to the fact that there is a batch of writ petitions pending before this court, wherein the fundamental issue regarding the question of accelerated seniority and oblique vis-a-vis catch-up rule, CATCH catch-up rule, is the central issue awaiting consideration of this court. Full stop. Therefore, this matter is also required to be taken up for hearing along with those writ petitions. Full stop. In view of the above, issue notice of motion returnable on 16th of February, 16th of March 2023. Since the respondent numbers 1 to 5 and 6 and 9 are already represented, no formal notice is required to be sent to the said respondent. Extra copies of the writ petition be furnished to the learned council, learned departmental council. Also, petitioner to take steps for service of notice upon the remaining respondents by registered post AD within 3 days from today. The official respondents to bring their stand on record by filing a detailed affidavit on or before 3rd March 2023. Full stop. Having regard to the facts and circumstances of the case, the departmental authorities are permitted to give effect to the order of promotion in favor of respondent number 9. However, such promotion will be subject to further order that will be passed in this case. The interim order dated 3/2/2023 stands modified to the above extent. Then the IS, where is the IA for?
But one thing I might add, the constitutional validity which your lordship has tagged up is WPC 363.
Let this matter be listed along with WPC number
363 of 2023.
363 of
Where
2023
the
and the
constitutional validity is checked.
batch of connected recognition.
My lord, 345 is implement
Yes.
and 346 is the order.
All right, we'll
application.
implement, heard Mr. K.N. Chaudhary and senior counsel assisted by Mr. R.M. Dekka, learned counsel for the applicant. Also heard Mr. D.K. Das, learned counsel assisted by Mr. H. Bethala, appearing for the writ petitioner OP number
9.
9.
No, OP number 1 or 1, my lord.
OP number 1. This IA has been filed with a prayer to include the applicant in the connected writ petition being WPC number 545/2023 on the ground that although the applicant had been promoted to the post of commissioner and secretary in the government of Assam due to the operation of an interim order in the connected writ petition, his promotion order has been withheld. Full stop. Mr. Das submits that he would not have any objection if the prayer for implementation is allowed. Mr. D. Saikia, learned AG Assam, assisted by Mr. P. Nayak, is present on behalf of the departmental authorities. Having regard to the submissions made by learned counsel for the parties and in view of the statements made in the IA, the prayer for implementation stands allowed. The applicant, namely Ranjan Sharma, be implemented as respondent number 9 in the connected read petition IS stands disposal. And it would give IA 346 of 23 লিখিব, heard Mrs. Kiran Chaudhary, learned senior counsel, assisted by Mr. R.M. Decker, learned counsel appearing for the applicant. Also heard Mr. D.K. Das, learned counsel, assisted by Mr. H. Betala, appearing for the OP number 1 read petitioner, and Mr. D. Saika, learned advocate general Assam, appearing for the official respondents. In view of the order dated as a date passed in the read petition, no further order is called for in this. The IA is accordingly closed.
Well, in the Langthasa's case, your lordship had directed the furnishing of the selection from the same prayer I'll call.
Yes, that you do it, let him,
That record they will produce,
That-
not on their paper,
no, that they will do it.
oblige.
These things don't happen anymore.
Certiorari proceeding, but are
Yes,
bound to
yes,
produce the
you'll
receipt.
get it. You'll get it, you will have your satisfaction, and of course, the court will look into your arguments, their arguments. There's no question of shutting out anybody. But we'll go by the principles and procedure that judicial
Because
system
from the
admits.
first position, now I'm 25. So unless I get the minutes, I need
No,
to
no,
challenge.
Mr. Das, you see, that you have been saying, that may be wrong, but that may be right also. We can't presume anything at this stage.
Since your lordship has given copies in the earlier case, I was just pointing out.
Can you give him? You can
We'll give you.
Oblige.
Advance copy will give.
advance copy.
But once the advocate.
Are you also proposing many more such actions? Why don't you give him advance copy?
Yes, it's like that only.
Huh? So that's what I said. This exercise is doing whatever else.
If
It
you
is,
don't do, you will not have the opportunity to appear before this.
that's correct. And it is also contributing to the GDP of the state. That's also important.
That is also important.
All right,
So
all right.
there is another IA of the state of Assam for vacating. That same order maybe.
Achha, which is that IA?
Number two.
It has come, we made a mention in the morning. We'll, give
Achha,
you-
if it comes, we'll close it.
Yeah.
We have got the copies.
The other IA, you right, had Mr. D. Saikal and Advocate General Assam, assisted by Mr. P. Naik, and counsel for the appellant. Also had Mr. D.K. Das, learned counsel assisted by Mr. H. Betala, appearing for the OP stroke read petitioner. Full stop. This IA has been filed with a prayer to vacate oblique modify the interim order dated 03/02/2023 in view of the order dated today's date passed by this court in WPC so and so. This IA, the prayer made in this IA has become redundant. The same is accordingly closed.
I-
Same part you write in the other case also, but add Mr. Chaudhary's name and other names. Okay, all right, yes. Next matter, please.
Supplementary list pending item, I think.
যাক, আপনি উল্টা ফেলেন।
মই ফালে।
There are recorded. May it please your lordship, this is the application for vacating the interim order by which the government is restrained from giving appointment to the selected candidates for the post of so veterinary officers and block veterinary officers. The selection was done in terms
Sorry, veterinary officers and
block veterinary officer, BVO, VO and BVO. The select list was challenged. The select list dated 23rd November 2022, where there is a recommendation of about 162 persons for appointment. The writ petitioners also participated in the recruitment process in terms of an advertisement, which was advertisement of 22nd of July 2022. That lordship will find at page 38 of the writ petition.
yes,
And the relevant portion of that advertisement is at page 43 of the writ petition. Regarding the mode of selection, direct recruitment, it is stated very clearly in the last paragraph of the advertisement. The selection procedure will be notified later on following by using corrigendum addendum if required. The commission will decide the provisions for selection in respect of any post or services considering the status, cadre, grade, and the number of applications received for the advertised post for service or services.
So in our advertisement, we have not indicated whether there will be a written test or whether there will be interview. But we said that among various other factors, the number of application will be a relevant factor to consider the mode of selection. For that, Lordship will have to take this honorable court to two rules. There are two rules governing the recruitment. If Lordship is pleased to take our IA filed by the state of Assam. There are two rules, page 56, the state rules of the department.
Page 56.
Page 56. This rule is called Assam Animal Husbandry Veterinarian Dairy Services Rules.
No, but it is not there in page 56.
54. It starts from page 54. And the relevant page is page 56, rule 6, direct recruitment. On a very narrow.
You are referring to IA number 16 of 2023.
IA number 3827.
Give me 3827. Where is 3827? The 3827 is filed by the state.
State of Assam, Lordship.
And the other IA is by.
The selected candidates. So page 54, the state rule is there. Assam Animal Husbandry Veterinarian Dairy Services Rules 1988. Relevant rule is rule 6, page 56, which states as follows. Direct recruitment to any cadre shall be made by the governor on the basis of recommendations made by the commission in accordance with the procedure hereinafter provided. Before each year, the government shall make assessment, etc. B, the government shall simultaneously request the commission to recommend a list of
You are
candidates.
referring to which rule?
Rule 6 of the 1988 rules of the department. Service rules governing the department. In page 56, down below on the right hand side. Direct recruitment to any cadre shall be made by the governor on the basis of recommendation made by the commission. Commission is APSC in accordance with the procedure herein after provided. Before the end of each year, the government shall make the assessment regarding the likely vacancies to be filled up by direct recruitment during the next year and shall intimate the same to the commission as provided in Rule 16 and carry forward such reservations. B, the government shall simultaneously request the commission to recommend a list of candidates for direct recruitment in order of preference. C, commission shall make a selection in accordance with the scheme of selections prescribed by the government in consultation with the appointing authority. The commission may hold such test or interview and undertake scrutiny of publication and other documents as may be considered necessary. So this is a relevant portion from the rules of this department. Now coming to page 58, Assam Public Service Commission's Conduct of Business Procedure 2019. This is, and they have challenged the selection process because according to them, the direct recruitment should have been done under the provisions of 4B. We have done it under 4A, page 59, 4A. So I have to place 4A, 4B, and 4D before this honorable court. 4A says direct recruitment only by interview. In certain situations, we can conduct the selection by only resorting to interview. In what situation that is contemplated here, Lord?
Page?
Page 59.
Yes.
Only by interview, where there is a provisions for selection only by interview in respect of any post or services, considering the status, cadre, grade, or where the number of applications received for the advertised post is equal to or less than 5 times the vacancies. The recruitment for such posts or services by the commission may be operated as follows. Eligible candidate may be shortlisted as per terms and conditions of the advertisement if required. Shortlisting shall be done as per the following table. So in our case, the total post is 162 and the applications we have received is 621. Right?
Eligible is 621 eligible applications. And the 5 times of the total notified vacancy is 810. আর তোমাকে কই দিবা permission? আমার 621 লেখা আছে my কানে কই আছে। So total application received which are valid 621. Total post notified is 162. If you make the 5 times of 162, then it comes to 810. So we have found that it is less than 5 times the number. APSC will give the details, Lordship. So according to this provision 4A, if it is less than 5 times, then only interview can be resorted to. 4B, according to them, we should have done it under 4B and 4D. What is 4B? There are various sub provisions of 4A which are not very relevant. But in one important part is, Lordship, Roman 2 of 4A, interview will carry 100 marks. In cases where the interview is a direct personality test, marks shall be allocated as below. 50% on academic, professional qualification, service experience relevant to the post, preferential qualification, additional qualification. 50% for subject knowledge and general bearing. 25% shall be subject knowledge and 25% for general bearing. In case where the interview forms a part of written assessment test on a subject relevant to the post or personality test, marks shall be allocated as follows. 50% for the written assessment, which is not relevant because there is no written test here. So others are not very important for the present list. 4B.
You want vacation of the order dated 29/11/2020.
Yeah, exactly, Lordship. Because all the selected candidates are ready. There is huge vacancy in the departments. We are not being able to fill up the post, which is substantial in number. Out of the about 700 posts, there's a vacancy of about 180 posts now. As a result, the various government schemes, central government schemes are not being able to be implemented effectively.
Mr. Chaudhary will hear the matter.
No, my lord, there is a blatant violation. Then if I'll take 10 minutes time. Let my last time complete, I'll make my submission.
No, you complete, you do it. What
Yes.
I'm saying is,
Yes.
these final issues will require some consideration.
No, my lord, if there is a violation of statutory rules, then there is no question, my lord. Here,
No, no,
here, my lord,
That's
what they
not
have
the,
done.
that's on the merit.
No, yes,
I'm saying that, so,
no, my lord.
If the
merely
posts are
because-
kept vacant, how
merely
does it-
Because posts are vacant, government cannot make an irregular selection. If the selection is otherwise all right, lordship will permit them. I'll just take 5 minutes time. Their case is the process which has been followed, which is under 4A. We say no, it should be under 4B, and why it will be 4B, I'll demonstrate.
no, that's all right. If it is an open and shut case, matter is different. If it is, Mr. Chaudhary, please consider this. I'm seeking your response. If it is an open and shut case and there is a huge prejudice, understandable. The issues are debatable and requires a finer consideration, the court will have
No,
to. hear.
lordships can perhaps.
Just let me.
Yes,
just
no,
let
I
me-
followed my lord, even I'm trying to give.
So
a
what is
handle
the problem is here is that the ultimate sufferer is the public.
to-
Because, yes, because if the posts are kept vacant due to court orders, projects are held up due to court orders. What, as judges, we are always conscious and we should be conscious.
Lordship will do the balancing act, my lord. What I'm not, even that lordships, that can be done, my lord. I'm not on that. All that I'm saying is, my lord, to the extent of the 20 petitioners, 20 posts will not be filled up. 21.
21 posts.
Keep 21 vacant for now.
That definitely I can agree, no issues at all.
That's all. We are not going into anything. like
Total
that.
cadre is 703, man in position is 532, vacancy is 171. That is the figure. If they get benefit, they will get benefit lock, stock and barrel, will not dilute anything.
Yeah, that is also because you see,
My lord, the
If they are successful.
prescription is the test should have been preceded by written test. Interview is subjective, we all know, my lord. The prescription, my lord, just one thing, my lord. Please
They
take
have
the-
participated and they have
No,
failed.
no, There is no bar, my lord, that I am prepared to argue. If your lordship should kindly take the writ petition, my lord, for a moment. Please come to page 43.
So there is a whole hog stay here. 20 petitioners and all.
And lot, and must say.
Kindly see, my lord, page 43 of the advertisement. I don't know, my lord, why APSC is taking this stand, my lord. We thought, my lord, APSC has improved. Nothing has improved, my lord. They're defending this. Kindly see, page 43
Page 43 of.
the writ petition. Of the advertisement issued by Public Service Commission. And they're taking a stand to the contrary. This selection procedure has a lordship got it.
Yes.
Page 43, towards the bottom, direct recruitment is the heading. Has a lordship.
Yes, please.
This selection procedure will be notified later on, followed by issuing corrigendum addenda, if required. The commission will decide the provision for selection in respect of any post or services, considering the status, cadre, grade, or number of applications received. The commission itself proclaimed that the procedure of selection will be notified depending upon the number of applications. Well, in this case, because the number of applications was more than 500, in terms of B, the interview should have been preceded by written test, which has not been followed. That's why I said, we have 21 petitioners, let 21 posts be kept reserved. And my lord, here in this case, there are about, my lord, the total number of applications were 621. So it is more than 500. Please come to page 73. 1 minute, my lord. This is 4B. We say it should have been under this. And we got to know about the number subsequently, where there is a provision of selection by, my lord, 4B, where there is a provision of selection by means of written examination and interview for any posts or services, or where the number of application is greater than 500 for the purpose of recruitment by a commission through written examination and interview. Or where the number exceeds 500. So it was more than 500. How can the APSC now
So
take it?
we'll hear the
Yes,
petition.
yes.
Because,
At 21 posts will be kept vacant.
Mr. Goswami, 21 posts kept vacant. Does it anyway offend your clients?
No, I am appealing for the selected 1 to 162. May I just take 1 minute? Good. Which your lordship will give in a IA. It starts at page 73.
Your IA is number 16.
16.
16.
16,
Yes.
you
How many applicants here?
162.
160. All of them.
All of them.
74.
Page 74, the APSC rules, Miller. That's at page 71. No? It starts at page 76 of that IA, Miller. If your lordships kindly turn to 73. Let's have a look at the provisions below of the APSC rules. Page 87, look.
Page 87.
Yes. If you got it, the rule starts at 76. And the procedure of the Commission for Selection and Recruitment to Post, it starts at page 82. There are different categories, different procedures. So we are not concerned with the earlier prescriptions because the eligibility and other things are quite different. If your lordship just kindly turn to page 87. This is for direct recruitment.
Yes.
And 4A, only by interview. So where there is a provision for selection only by interview in respect of any post or services considering the status, color and grade, or where the number of applications received for the advertised post is equal to or less than 5 times the number of vacancies, recruitment for such post or services that the commission may be operated as follows. So there are two situations under 4A, where only by interview the commission can recruit. First is where there is a provision. My learned Advocate General has already placed Rule 6C, interview or test. So they have decided on interview. So first part is satisfied. Alternatively, if your lordship see, or where the number of applications received for the advertised post is equal to or less than 5 times the number of vacancies. The advertised vacancies was 162, 5 times thereof is 810. The actual applications received by APSC is 695 and valid applications eligible and accepted, which is notified, is 622. So, either view of the matter, this is the only method by which it could have been done, namely 4A.
So what have they done? They have held it by interview only.
Only by interview. That's the case of APSC. That's the case of government. Therefore, your lordships, very right, it might take a little while. So your lordship may vacate subject to the outcome of the case.
So total writ petition are the 21.
21.
So we'll make some provision to protect their interest.
No, let us see, 162 are selected out of a large number of vacancies still. So they have gone through a process. Suppose this petitioner's petition is allowed tomorrow. He doesn't get a appointment. It will be a direct another process of written test and all.
There can't be a mandamus to appoint them.
Correct. Therefore, suppose it is dismissed, we get the relief because together we faced the interview. We are selected. They also took a chance. They have not got it. Therefore, my lord, if the appointments are made, subject to the outcome, if they succeed, the result will be the alternative. So why make a distinction between the selected candidates?
All right.
21 and others.
All right, Mr. Mohan.
My lord, I clarify his then, my lord. Your lordship kindly, probably he also give answer to my question. His only point is that we are going by only interview. Why? Because rule says either way, by written test or interview. We adopt one interview because there is, if you cannot go written test and interview, because it is rule does not provide. This advertisement was published as per my lord rules of the department. That is what clearly mentioned. And we notified it. We fixed the date of the my lord interview. They have availed it. We declared the result. After that, when they came to know that you are not selected, then they came before this honorable court. No, you have filed a written case. But written case or interview, we have adopted it. So we have not committed any wrong, my lord. And those who are, it is less than, my lord, 5 times. That's why, my lord, we are all allowed to appear in the interview, my lord, for keeping the transparency and everything, my lord. So now, my lord, they cannot say that, my lord, they are getting their chance. They did, what is the malafide and what is the arbitrariness on the part of the APSC, my lord? Because we follow the procedure, we follow the advertisement, we follow our own procedure. So that's why, my lord, there is no prima facie, there is no illegality committed, my lord.
Yes, Mr. Chaudhary, I
Just
wanted
take
to.
2 minutes time.
Well,
Because I have to reply to my learned.
no, just 1 second.
Yes.
Give me 1 more second.
Of course.
There is one more consideration why this distinction will not be made. May I just point out that? Milord, the advertisement my learned friend has placed that there may be APSC will notify the method, the procedure of recruitment. That was notified, which the writ petitioners didn't mention. And we have annexed that, your lordships will get that at page 73. It was notified and it is a notification which the petitioners had to act upon in order to appear before the interview, which they did. This is the notification dated 2/11/22. It is for information of all concerned that Assam Public Service Commission will hold interviews viva voce for the post of veterinary office so-and-so as per program given below at the office of so-and-so, and then below dates are given, then the last part. The intimation letter shall be uploaded in APSC's website on 9/11/22, and no individual intimation letter will be sent separately. The candidates shall have to download their own intimation letter from the aforesaid website. Further, except reject list will be uploaded on 7/11/22. Therefore, this is something not merely a notification of a date. The candidates are required to act on it and they knew about it. And if their contention is that this interview should not have taken place, instead written should have been held, this was the time when they have to take that call. Otherwise, you take a chance and the Supreme Court judgments are quite settled on that. That is one, this suppression. Secondly, kindly see the rule which they annexed in their writ petition. It's not the full rule.
So we'll continue.
Yes.
Yes. No, I think lot will have to give some time. I'll place the judgment of the Supreme Court.
Let them file affidavit.
No, the records itself will reveal that there is no 2 proceedings pending. That instruction, I just saw it, my lord. The instructions itself will, I know that, my lord. In the second proceeding, I was exonerated. Their case is that in the second case, I was under suspension, so the increments were stopped. How can you bring it in the first case? That much will take a lot, because he's retiring on 31st of March, my lord. He's retiring on 31st of March. Even if a review DPC is
Which is the item number?
15, my lord. Any date, my lord, convenient to your lordship, my lord.
List on Tuesday.
Tuesday, lordship.
On the request of learned counsel for both sides, let this matter be listed again on Tuesday.
My lord, can I take a little liberty? 24 and 25, could it come up on 30, my lord? Oh, sorry, 28 tarikhe itu mahon.
Second.
No, moi na. Friday can I get a hearing? Second, my lord. Deep level.
Item 24 and
25.
25. Hearing matters.
all right.
May I please? What I was trying to show the projection of the case mirror, because that will have a bearing. First, let me show from the writ petition. 2009, Annexure D, page 71. The amendment of the APSC rule is annexed. Now kindly see, the amendments are only there, and at page 73, 4A5 to be newly inserted. Then 4B. And the argument entirely is based on 4B. 4A, I'll just show what 4A is. It is not even brought before the court. Now kindly turn to our application. We have annexed the entire rule, at page 74 it starts.
So, Mr. Goswami, I have understood your plea. I just wanted a response from him and then pass the order.
I'll just give me 2 minutes, I'll close. 74, it starts.
Yes.
From 76, preamble, I am not troubling your lordship. The relevant rule is at page 87. Four A,
Yes.
only by interview. I have placed the relevant clause
Page 87 of?
my I
16.
I number
16.
16.
All right. Yes. Only by interview.
Only by interview. This is not even brought before the court. And C4B at page 88, next page. Only this is given. But the categories are kindly C. It's not just only A and B. C, written examination, skill examination, and interview. So it is all different. 4A is only by interview. 4B, written competitive examination and interview. 4C is by examination and skill. D, screening test and interview. So it goes on. So different procedures. In this case, as the APSC affidavit clearly states, it's by direct recruitment. 4A. A. Because the two conditions are satisfied, and therefore they have only gone by 4A. And that is not even placed before the learned single judge. And the whole case is based on 4B, without bringing to notice 4A. Now, if that is the position, these two omissions, one, that notification which your lordship has seen, notifying the procedure of interview and which you have to act as a candidate to get your call for the interview, that is not even mentioned in the writ petition. Page 24 only says we are called for interview. Nothing about this document. We have annexed it. Secondly, this omission to give the relevant clause of 4A, that in my respectful submission, I have just given Miller a passage from Sylvia Miller, if your lordship said that. It's a very elastic jurisdiction, Miller. You must come with clean and open hands. It's an equitable relief you will give. Everything is taken into account in considering whether a relief is given. Just have a look at that, Miller, at page 1612. I'm just giving you a lordship. That is really such a bad. It is paragraph Miller 16270. Survive 4th edition and page 1612, para 16270. Improper conduct in presenting the petition. The decision in so-and-so has been treated in India as the leading decision on the good faith required of an applicant for a writ. The decision is accurately summed up in the head note below. If on the arguments showing cause against the rule nisi, the court comes to the conclusion that the rule was granted upon an affidavit which was not candid and did not fairly state the facts, but stated them in such a way as to mislead and deceive the court, there is power inherent in the court in order to protect itself and prevent an abuse of its process to discharge the rule nisi and refuse to proceed further with the examination of the merits. This is my respectful submission. Two omissions are vital. If these were placed before the learned single judge, particularly 4A, whether he would have passed this order or not is a matter of speculation, my lord. And the learned judge in his order says at this stage, I am only passing that order. Kindly see, we have edited that order.
Which part of the order restrains further appointment?
Yes, below 4B, the order is at page 29 in our IA. Page 71.
In your IA?
In my IA, it is page 71, I think. It starts from 68, I think.
Yes.
67, in fact. Starts at 68, my lord. And if your lordship see, his lordship is only considering 4B and 4D5, page 69.
Yes, I have got it.
Yes.
I have got it.
And he significantly states, my lord, his lordship, at this stage, therefore, the considerations were page 71. The court, after hearing the parties on the perusal of the procedures laid down in the public APSC conducted business 2019, it is a considered opinion at this stage. Now, what has it said? 4B. Therefore, my lord, in my
Four A was not at all considered.
that was not even placed before the court. Full rules were not placed. That's why I'm saying it is not candid, my lord. You have to come with candid hands and show. Then you make out a case without showing the relevant rule, which APSC is saying, and which the rule itself indicates only by interview. Therefore, there was a procedure which was notified, that is suppressed, and the rules on the basis of which that was done, that is not brought before the court. Therefore, my lord, I don't think equitable relief is called for at this stage, because veterinary rule, rule 6C clearly says it may be either a written test or interview, and therefore they have gone by interview under their 4A. Therefore, all these questions, my lord, picking up one and one, 4A itself indicates what is the number required 5 times of the advertised post. 162 into 5 is 810. The applications were 695, as APSC has pointed out. And they have found some invalid, so effectively 622, which was notified. And then the interview notification came. Therefore, it will be very not logical to differentiate between this group and say because there are 22 petitioners, keep 22
Very well.
else. That will be illogical. In any case, because I am told there are more vacancies, so they should have no problem. But what I am saying is that suppose, my lord, even that is there, ultimately this petition is allowed, they have to my lord, go through that process, every one of us. But if the petition is dismissed, why should this
Correct, balance of
20
convenience.
along with
absolutely.
the same be deprived? Therefore, my lord, it has to be a logical end.
We have aptly clarified all the issues. Let us now just
Yes,
think what it
everybody.
is.
My lord, if we are to go by what my learned friend says, then my lord, illegality in a selection process is of no consequence. That's what my learned friend has just now submitted.
I have not submitted.
Of course, lordship, my learned friend has submitted that. The
don't
consequence of what my learned friend has submitted is,
Don't put
even
that-
if there is any illegality in the selection process,
I have
court
not
should
said-
stay away.
No, no.
In substance, what else it is?
No,
Anyway, my lord. Now, my learned friend says,
don't
we did
put
not,
it into my
we
mouth
do not
what you
bring
are
anything to the notice of the honorable single judge. My lord, how do we know which rule was followed?
That's all, Mr. Chaudhary, we are not going into all this.
All right, let us come to the merit. My lord, please come to, I'll just refer to 4 passages. Please come to page 43 first. Oh, sorry, page 73 first.
Page 73 of.
Yes, of writ petition.
Yes.
First, I will say what is my case, then I'll say, show my lord, why their case is preposterous. Where there is 4B, where there is a provision of selection by means of written examination and interview for any post or service or services, or where the number of applicants is greater than 500 for the purpose of recruitment for such posts or services by the commission through written examination and interview. That means if the service rule provides for both written test and examination, or in a or an interview, or in a situation where the number of application is more than 500, in that case, the procedure will be written test and interview. Am I clear, my lord?
Yes.
Now, my lord will kindly come to page 74. 4D, Roman 5 on top. Now, I'll say, my lord, this was not your lordship notice. Therefore, he should not be heard. The total number of candidates, because they have annexed the whole rule, why they have not brought out this your lordship notice? The total number of candidates shortlisted for interview will be as per ratio decided by the commission, where the total number of posts advertised is equal to or less than 50. The ratio of candidate to be called for interview will be 1:5. If the total number of posts advertised is equal to 51 or less than 75, the ratio of candidate to be called for interview will be 1:4. And if the number of posts advertised is equal to 76 or above, the ratio of candidate will be called for interview will be 1:3. 162 into 3 is 486. Why 621? My lord, the purport of rule 4A or B is either the service rule provides a particular procedure or you follow this. Now please come to page 43, which I've shown. I'll show it once again. What is the purport of this? Page 43. This is the advertisement issued by the APSC. This selection procedure will be notified later on. Will be notified later on, followed by issuing corrigendum addendum. If, as a lordship got it, my lord, if the required, the commission will decide the provision for selection in respect of any posts or services, considering the status, cadre, and grade, or number of applications received for the advertisement. Because when the advertisement was issued, APSC was not aware what is the procedure to be followed. They will get to know whether to apply 4A or 4B or 4D only when the number of applications are there. Now, number of applications being more than, my lord, 500, what option they had? And what is the wrong projection on our part? Well, what more clarity is required? Now, my lord, when will 4A come into play? Only when the service will provide. And my learned friends has not completed the whole 4A. Please come to rule 4A in their petition. 16. If a lordship will kindly have, page my lord will kindly come to page 87. 4A.
Yes.
They are relying on this, both state as well as the private respondents, where there is a provision for selection only by interview in respect of any post. That means, my lord, the service rule must provide only for written interview. Their service rule provide both written or interview. Where there is a provision for selection only by interview in respect of any post or service, considering the status, cadre, grade, or where the number of applications received for advertised posts is equal to less than 5 times the number of vacancies recruitment for such posts or services by commission may be operated as follows. Kindly see, my lord, what has been envisaged in the rule is between 51 to 100. If the applicants are more than that, then nothing is prescribed. Therefore, 4B will come into play. My lord, had it been a case where the recruitment rule would have prescribed only interview, then, my lord, 4A will apply, provided the number of applicants is less than 100. The moment it is more than 500, it has to be by written test and interview. My lord, let me ask a question to myself. My lord, which is a better option? Written test followed by interview or interview? We all know, my lord, interview is a very subjective. What is in public interest? My lord, this is a rule framed for the, APSC. My lord, is it so unintelligible that it is not known to these APSC members, my lord? And an argument is advanced, we have not come with clean hands. You are beneficiary of an illegal selection. This argument doesn't lie in your mouth. Absolute illegal selection.
So what is the ultimate relief you are seeking in the?
Ultimate relief, my lord, this whole selection has to go and they should advertise the post afresh. Alternatively, Lordship may do one thing. Beyond 486, those candidates should not be considered for recruitment because they can call for only 1:3. They have called 622. And my lord, in that group of, my lord, between 486 and 621, there are, my lord, 21 candidates, 34 candidates. Out of 162 selected, name of 34 candidates appear between 486 and 621. My lord, what meaning APSC will give to 4D5, which I have read, my lord? If it is more than more than 76, it has to be 1/3. So, my lord, their argument is absolutely based on a wrong premise. It is only when the service rule will say that interview is the only mode of recruitment and the number of applicants is between 51 and 100. In that case, my lord, they may be justified. But that is not the position. So where is the question of, my lord, vacating the interim order? Is it not a case where more than a prima facie case has been made out? My lord, this matter does not require any much more, hearing, my lord. Lordship can have it in the 22nd or 23rd. Lordship dispose of the whole matter. I don't think, my lord, I don't think any prejudice would be caused to the state by waiting for another 3 weeks, my lord. I would have agreed to next week, my lord, but because I'll not be there for about 7 to 10 days. That's why I'm saying, my lord, the lordship takes it up on 27, I'm done, my lord. Otherwise, I don't think it's a case where interim orders should be interfered with at this stage. My lord, and regarding participation, that also I can satisfy lordship. My lord, in fact, the Raj Shakti's case is precisely on the point which I am arguing. If they say that we have participated and how can we? In fact, this has been answered in 1997, 9 SSC 527. Please come to para 16 of the judgment.
When are you free?
My lord, actually, I'll be back. My lord, because before our case, that Maharashtra matter is there. So we are thinking, but next 2 weeks it will be over. So 27th, I'm back. I'll be attending court. Maybe before
What
also.
about a fixed part-heard matter in the writ petition? You listed as fixed part-heard on 27.
Yes.
The writ petition, we'll finish it off.
Allow me, my lord, what he has projected is not his case, my
Oh, that's right. Fixed part-heard matter. Are you available?
My submission, your lordship may allow us to fill up the post barring 21.
We'll finish it off. 27th, you will get the judgment. You will get the judgment on 27th of
Yes,
February.
yes.
I'm not going to adjourn it on
Yes, yes.
any circumstance.
Yes.
Only thing I'll not be present, your lordship, because I'll not be here on.
Actually, you are not there.
My lord, this point, my lord, regarding if your lordship allow me, I'll clarify it right now, my lord. Because we have, no, my lord, your lordship kindly see
We'll
what.
take it up on Monday for final hearing.
Monday, I'm not available, lord.
Tuesday,
Monday, Tuesday, no. Wednesday, I'm available.
Wednesday,
Next, my lord,
coming Wednesday,
I'm not there. That's why I said 27.
then we have to consider this.
No, my lord,
Nothing can be done.
lordship can have it on the following.
Because
my
he
lord.
has already categorized 2 persons, that 34 posts who are beyond 386 or
Huh.
486.
Yes.
That way, that categorization can be made.
According to
Because
him,
between-
1:3 is to be called.
Ah,
But
for-
he won't be agreeable to that and I have to give a reasoned order.
That's right. Either it
But-
is good or it is bad. It can't be just, you make
Can
a
be partly good,
distinction
partly
between
bad.
the two. Only thing I
My
can
lord,
point out.
27th, we
apparently
will all
that-
appear, oh, sorry, my lord.
I'm telling you.
What did you need to
I'm
know?
telling in your favor. Beyond for the advertised post of 162, I understand my learned friend will find out. There are vacancies. So there are vacancies which were not advertised beyond 162. So they can be protected for those vacant posts if they succeed. But they
Are there more
they will not
vacancies?
get up, if they succeed also.
My
they will
report
not
says,
get-
instead of 162, we have present vacancy.
So,
position.
Mr. Chaudhary, if we direct that your client should be appointed, then you don't have any problem.
No.
No, no, my lord, I'm not saying that.
Hmm.
I don't want that. There cannot be an order for my appointment. Question is, my lord, if the selection goes to the root of the matter, if it is a bad selection, Lord Chief will interfere. If it is a good selection, Lord Chief will interfere. It's only a matter of 2 weeks. Within 2 weeks, nothing is going to happen, my lord. My lord, actually, it's not that, otherwise I'm really finding it difficult to say. 27th, yes, I'm done. 27, 28, 29, any date, my lord. This,
But Mr. Goswami will
I
be
think
around.
27th is not there.
My humble submission, where Lordship may allow us to fill up the post. If they are successful, Lordship,
All right, then argue. I'm reserving judgment in the writ petition. Argue. Other matters I'll not be able to take up today. Anything else you want to add?
As a petitioner, let me complete it, my lord.
my argument is over. That is, from government's point of view, we have that urgency of filling up the post as soon as possible.
My lord, let me also complete my argument. I'll take just another 5 minutes. My lord, the writ petition has been structured on the basis that it is 4B, which is applicable in the instant selection, read with 4D. Now, the number of posts being 162, the number of applications, sorry, it's more than 500. Therefore, as per 4B, there should have been a written test followed by interview. And when it comes to the interview, they could not, whether it is under 4A or it is under, my lord, 4B, in any case, interview only, my lord, 1:3.
All right. And you wanted to cite some decision?
Yes, I'll cite my lord. And let's just, whether it is 4A or 4B, in terms of 4D, interview, it cannot be, my lord, more than 1:3. So that way, my lord, by calling 621, my lord, they have committed a wrong. Thereby, my lord, they have reduced our chance of getting, even if there is a future advertisement.
No,
Number one.
Future vacancy.
No,
cannot be
even,
filled up.
no, my lord, supposing the posts are filled up, then they could not have, anyway. Then, my lord, my second point is,
So, Mr. Chaudhary, only issue the court would go into
yes,
are couple.
yes,
And let me put it very straight to you.
Yes.
Other aspects I am not even going to touch in my judgment.
my lord,
First of all, the recourse adopted in this selection process, was it a permissible means under the rules?
Yes.
This is number one.
yes,
Number two, even assuming that it was not a permissible mode,
Mm.
even then, the test of prejudice would be applied in the sense that if the rules and the procedure has been uniformly applied and it was known to the candidates,
Mm.
then even if it is illegal, whether it should be interfered or not.
thereby submission would be,
Hmm.
anyway, I'll just take 5 minutes. then.
Yes, please, please.
My first submission is this selection should have been done as per rule 4B.
Hmm. All right.
Now, 4A, even assuming 4A is applicable, it is only by interview.
Right.
Then also they could not have asked, call for 621. In that case, they could have called for only 486. By calling for more than, my lord, 486, my lord, persons who are not eligible, now their cases have been considered. Therefore, this selection vitiates. Number 2.
But your client's cases have been considered.
Yes,
Then
consider. No, I'm coming. Now, my lord, let us come to the second point. That is whether our participation has stopped us from challenging it. That's the only point. Oh, first point, my lord, I'll rely upon true judgment. That when there is a statutory violation, the selection vitiates. There, my lord, once the rules are mandatory, it has to be followed. My lord, I'll rely upon two decisions. 2004, 7 SCC 111, paragraph 35 to 40. And my lord, 2013, 2 SCC 516, para 50 to 55. Now, these are all known propositions. I will not trouble your lordships. Now, this 1997 9 SCC 527. Here is a case, all perimetry of facts.
Give it my chamber.
Yes. My lord, with para 16. Para 16. Yet another circumstance is that government had not taken out the post from the purview of the board, but after examinations were conducted under 1955 rules, and after the results were announced, it exercised the power under proviso to para 6 of 1970 notification, and the posts were taken out from the purview thereof. Thereafter, the selection committee was constituted for selection of candidates. The entire procedure is obviously illegal. It is true, as contended by Sri Madhava Reddy, that this court in Madan Lal and other decisions referred therein had held that candidate having taken a chance to appear in an interview and having remained unsuccessful cannot turn around and challenge either the constitution of the selection board or the method of selection as being illegal. He is stopped to question the correctness of the selection. But in this case, the government have committed glaring illegalities in the procedure to get the candidates for the examination under the Rule 1955 rules. So also in the method of selection and exercise of power in taking out from the purview of the board and also conduct of selection in accordance with rules. Therefore, principles of estoppel by conduct or acquiescence has no application to the facts in this case. Now, here in this case, my lord, the candidates who will be called for selection, there was an infraction of the rules. How the candidates would be selected, there was infraction of the rules. In these facts, the Honorable Supreme Court said, it cannot be said that principle of estoppel by conduct will not apply. Now, let us apply this case to the facts of this case. They are saying that it is by application of Rule 4A, that is only by interview the selection is to be made. Well, number one caveat is this service rule or the recruitment rule does not envisage that it will be only by interview. It says test, written test or interview. So therefore, 4A will not come. Assuming for the sake of argument, my lord, 4A applies. Then when it comes to whom to call for interview, then you must take note of 4D, whether you have done it.
What is the pleading to that effect?
Yes.
Even if 4A is presumed to be applicable, what is the pleading here?
Yes. Our case is, my lord, kindly come to para 14.
Now, if that is accepted, then how does one figure out who are the ones to be included in the 486? Who are the ones to be included in the 486 today?
No, 486, my lord, beyond 486 applicants, then they will have to, they will have to reject them.
Correct. So
Yes.
the 162
So
selected.
there are, my lord, between 486 and 621, there are 34 persons who got selected. 34. My lord, in my humble submission, the whole selection vitiates. There has to be a fresh selection. Because there is an infraction of the rule. The moment there is a violation of rule, which is of mandatory character, there is nothing like, my lord, substantial compliance. Once rules are mandatory, it's mandatory. Either you follow or you perish. Manner is prescribed, it has to be done in manner. Any other mode of performance is forbidden. My lord, will kindly come to paragraph, my lord, 14, my lord.
Paragraph
Yes.
14.
Yes.
Yes. Good, Guldan.
This is our case, para 14.
Read petition of sub party naam likhe lo. Yes.
Para 14, page 31.
Yes.
That the respondent APSC in the advertisement had stated that the commission will decide the provision of selection considering the status, cadre, grade or number of applications received for the advertised post. That is page 43, my lord. Therefore, APSC after shortlisting of candidates to 621 should conduct written test in terms of amended clause 4B. However, no such steps were taken by APSC just to favor respondents 5 to so and so. As such, it is a case of glaring illegalities resorted by the respondent while conducting the selection.
Is it 621 or 622? Different figures.
Oh, sorry, my lord.
622.
Sorry. I'm sorry, my lord. This could be corrected.
And you say that because if the ratio of 1:3 is maintained,
Yes,
then the number is 486.
486.
Because total advertised,
162 into 3,
and that you say because rule 4A,
4B,
B,
4D by 5, my lord.
correct.
4D.
But 4D5 will come into play
Yes,
if the court holds that this is a recruitment process which comes within the purview of 4B.
no, my lord. My humble submission is 4D5 will apply irrespective of whether 4A or 4B. When it comes to how many will call for interview,
All
then
right.
that
Now, why do you say 4A is not applicable here?
4A is not applicable for the simple reason the number, no, my lord, they could not explain. Please come to page for a moment, page 87.
No, according to you,
Yes,
what is, you have a stand in the matter. So why do you say 4A is not applicable? here?
4A is not applicable for the simple reason, number one, the recruitment rule does not specifically provide for interview, number one. And number two, my lord, 4A deals with a situation of maximum up to 100 candidates. Beyond 100, it does not envisage any criteria. They are finding us fault with us for not showing. Who has read 4A into Toto, my lord?
So, all right. So you do admit that 4A contains a provision only for interview.
Yes.
The question is whether this selection would fit into 4A or not.
No.
If
4A
it fits in,
yes, yes.
then you are out.
Yes, my lord, 4A will not apply. The second reason is, please come to page 87 of the application filed by the private respondents, my lord. No, page 87.
Page 87.
My lord, 16, IA 16.
All right. Yes. Yes, please.
Kindly see, my lord, the table which is appended, it speaks of 51 to 100. Beyond that, there is none. What will happen, my lord, if it is 100 to 150, if 151 to 200, 200 to 250, and so on and so forth? It visualizes a situation where the maximum number of candidates will be 100. Now, if we logically, apply the thing, my lord, why 4B had to be introduced? 4B had to be introduced because there are more applicants. Written test is more objective.
Therefore, what follows from your argument is that the court will have to hold that provisions of 4A will be applicable only if the maximum number of candidates is 100.
Yes.
Moment it is 101, 4A will have no application. It has to go to 4B.
4B.
And that is despite the fact that it says eligible candidates may be shortlisted.
Yes.
So this expression may has to be read as it must be.
No, my lord, may has to be read in the background. Attending facts and circumstances, taking rule 4A as a whole, in my humble submission, it envisages or deals with a situation where the maximum applicant would be 100. If it is more than 100, no provision is there. Therefore, we cannot infer anything, my lord. Now, there is an express
That is
provision.
correct, but Mr. Chaudhary, just you are making an interesting argument.
Yes.
I'm trying to understand the
Yes.
point. So if just because this particular illustration or whatever you call it stops at 100, are we to read that beyond 100 it is prohibited? Is that the argument you are making?
No, then my lord, 4B will come into play. Now, let us come to 4B.
No, but 4B is not only by interview.
Both written and interview.
No, you see, let me formulate it. We are now considering whether there is any provision in the rule which permits only by interview. That's settled. There is a provision. The question is, would that provision be applied in the facts of this case? You say no, because beyond 100 number of candidates, the illustration does not reach out. Correct? So according to you, it will be only by interview if the total number of candidate considered is 100.
My lord, why I'm saying so, there is one more reason.
Hmm.
Please come to the fourth column at page 187 and you
Yes.
see when the number of candidates is between 51 to 100, then maximum, my lord, 3 times it can be called. Suppose in case of 500, how many times will be called? Who will determine that, my lord? By process of, my lord, inference? Now, my lord, if we have to postulate a situation
No, but why 5 times will not be applicable?
where, my lord,
In page 87,
yes,
the IA, 51 to 100 also talks about 5 times.
yes.
Correct?
Hmm.
Now, that's the question
No,
we
my
are
lord,
coming
yet
back to.
it says 5 times of 100, my lord.
But beyond 100, no scope.
No, that's what my lord.
No, I'm trying to understand.
Yes. In my humble submission, yes, my lord. The rule 4A does not deal with a situation when the number of applicants is more than 100.
Then it has to be essentially interview plus.
My lord, the reason is very simple. If your lordship leans in favor of 4B, what would be the prejudice that will be caused to anybody? Because it prescribes a more objective test, written.
No, that is
No,
a different
no.
matter. That is a different
Supposing
matter.
there are 2 views. Supposing there are 2 views.
Hmm.
One view says X, another view says so and so. If the other view leans towards more probity, why court will not accept that, my lord?
No, Mr. Chaudhary,
No.
here I have to clarify one thing because you must get a chance to address the court on this. You see, the court is conscious about 2 things very clearly. We are not in the realm of what should be done.
Definitely.
We are in the realm of what has been done. Is it permissible?
Right.
The test is much higher than merely making out a prima facie case.
Correct.
The state or its apparatus has carried out a recruitment process involving number of working hours, resources, etc. And there is a select list published. So to interfere with that select list, the court has to be, the conscience of the court will be absolutely clear.
Absolutely.
Something abjectly wrong has happened. And the petitioners did not have a chance to flag this issue.
Or in other words, the action must result in failure of justice. Because
All right,
lordship
all right.
will issue certiorari
All right.
only when it results in not mere infraction.
All right. So therefore, these 2 parameters will be different.
Yes.
Supposing today you raise this issue and they are about to conduct a selection test, there the parameters will be completely different. But now it has already been done. If we allow your prayer, that would take away the
Yes.
fruits,
Yes,
right?
yes.
But it's not going to give you anything, except that these vacancies will be again advertised.
And where
That's
you
all.
get an opportunity, where a
You
right
get an
procedure will be
opportunity.
followed.
Correct.
There if we succeed,
Correct.
don't succeed.
And
we'll go.
this opportunity of yours could extend maximum up to 21 vacancies. Correct?
No, my lord. If the procedure is wrong, lordship will go whole up. No, for the present is lordship was thinking whether
Yes.
some interim protection could be given. That was for the present.
Yes.
But while deciding the writ petition finally, lordship will take a call whether the application of 4A was correct. If lordship holds it was correct, fine. If your lordship holds it was not correct, then lordship will interfere. There's no question of
That's
21.
correct. That's
Yes.
correct.
So my humble submission is, my lord. Now 4A is not very clear. Let us also say that 4B is also not very clear. Now there are 2 options are available before this honorable court. I am making an submission in favor of 4B because it is more objective and it will rather further probity in the selection process. It will bring in more transparency.
No, that's
But
correct.
subjectivity-
That's correct.
subjectivity-
But you are saying they should have gone for 4B. We are on, they have gone for 4A. Is it permissible?
No, I say 4A is wrong for the simple reason, my lord. Number 1, recruitment rule does not provide. Number 2, the number of vacancy being more than 100, 4A cannot apply. And number 3, my lord, by a process of inference, perhaps, my lord, we cannot make rule 4A applicable in this case because of, my lord, the conflicting, results which will emerge if we take a dogmatic view in the matter. But if we take 4B, my lord, it will be more rational. It will add, my lord, probity to the whole selection process. And nobody can grumble, my lord, if a student is subjected to a written test. These are all fresh candidates. It's not that, my lord, after 10 years of ad hoc service,
What you
somebody
are
is.
saying is very wise. But then wisdom is not the issue here.
No, sir.
Issue is whether,
No, my lord, my humble submission
no,
is.
you are entitled to make your
Yes, yes.
arguments. Mr.
So my humble submission is very clear.
And the court will
4A
consider
is
it.
not applicable. By any legal reckoning, my lord, 4A cannot be made applicable.
Right. So I think
That's my humble submission.
we can set it rest, right?
Yes,
now?
yes.
So I am taking up the writ petition for disposal.
Yes, yes.
Yes, take down heard Mr. K. Chaudhary, learned senior counsel assisted by Mr. R. M. Decker, learned counsel appearing for the writ petitioner. Also heard Mr. D. Sekia, learned advocate general Assam, assisted by. Yes, Dina. Now he is visible. Learned senior government advocate Assam appearing for the respondent numbers. Respondent number 1. Mr. T.J. Mohanto, learned senior counsel assisted by Mr. P.P. Datta. Learned counsel appearing for the respondent numbers 2, 3, and 4. First up, Mr. P.K. Goswami, learned senior counsel assisted by Mr. B.P. Bora, has appeared on behalf of respondent numbers 5 to 165. Arguments concluded, judgment reserved.
Deeply obliged.
Yeah, only one thing, if your lordship, just as a response, it says that if it is beyond
My lord,
100,
with the lordship's kind permission.
yes, if it is beyond 100, 4A doesn't apply. That's the argument. Just have a look at the column, my lord.
Look at,
Look at the column itself at page 87.
yes.
There are two things, my lord, where the number of applications are more than the number mentioned in column 3.
My lord, I'll.
What is the column 3? The one he read, that 5 times, and 51 into 100, 5 times. If it is more than that, applications are more than that, then, my lord, the number of candidates to be called for interview after shortlisting, and there is an austerity. The criteria for shortlisting will be decided by the commission. Now, commission has decided it is more than below 500. 5 times of 100.
My lord,
So,
that point, my
We'll
lord.
close the matter now.
no,
Yes.
yes, but
Chaudhary,
and the commission has given in its affidavit that they
in
have.
IA Civil 16 of 2023, in page 87 and 88, 4A and 4B. Please quote it. Please type it down somewhere. I'll cut paste when the judgment is. All right.
May I only point out one thing about the judgment cited below, 97.
Mhm.
Your lordship may just note the paragraphs. I don't want to trouble your lordship. Page 33, 533.
Yes.
In the middle, it is mentioned, it is seen that the procedures adopted both under 55 rules and 9070 notifications are not correct. That is one. Then 536. Clear finding. In para 16, towards the last portion of that paragraph, but in this case, the government have committed glaring illegalities in the procedure to get the candidates for examination under the 55 rules. So also the method of selection and exercise of power in taking out from the purview of the board, the statutory authority was the board. They were not even consulted. And also conduct of the selection in accordance with the rules. Therefore, the principle of estoppel by conduct or acquiescence has no application to the facts of the case. It is on these premises that they said that the normal rule which is set by the Supreme Court, and your lordship can note that judgment, if your lordship's 1 Miller, 2013-11 SCC 309. If you take a chance and don't succeed, you can't get a release. That is at para 21 and 22 at page 319. This is below 2013 11 SCC 309. And the other case is a this is a settled position, but I'm just. This is more recent, that's why I'm giving 2016 1 SCC 454. Paragraph 14 at page 460. Deep level.
In my affidavit, everything I have stated, my lord, I want to be pointed out that, my lord, the 21 candidate, my lord, they were allowed to sit in the examination because of they are overage, but by virtue of court order, they are allowed to sit, my lord. And your lordship.
These 21 means read petitioners.
No. In that list, to tell we have received 695 applications. 690 out of 699, we found it, my lord, 622 are valid, they are allowed to appear in the. All are allowed, all of them.
were called,
That's
whoever-
why, my lord, in 4A, one sentence was not been read by anyone. Eligible candidate may be shortlisted as per terms and condition of the advertisement, if required, then only this will follow. Otherwise, my lord, if required, then only will follow this person, my lord, this portion, my lord. Otherwise, not, my lord, because here what happened, my lord, it is slightly less than, my lord, 4% and more than 3%. We are called. That's why we are allowed to all of them to appear in the interview, my lord. Nothing, my lord, wrong has been done, my lord. There is an alphabetical list we have prepared who are those who are they are eligible to sit in the interview, my lord.
So whoever is eligible has been.
Yes, and my lord, why we are not going to 4B, my lord? Because if 4B is, my lord, interview and written test, but that my lord rule does not permit written test and interview. Rule permit only written test or interview. So we cannot take both. If we can take both, if we go by 4D, then it will violate of the rule, my lord. So that's why we are adopting 4A. And 4A, my lord, there is nothing wrong, my lord, because in the advertisement itself, it is clearly stated, the advertisement, my lord, that was as per the service rule. Because we cannot, APSC cannot publish the advertisement sent by the department as per the service rule. We advertise it, my lord, and as their service says, only interview or written test. We adopted interview, and 4A is coming, my lord. That's my argument.
All right. The judgments, copies will be given.
Yes, I like I cited, I'll give.
All right.
Masum.
I'll try to deliver the judgment as early as possible.
I will do. 497, 97, your lordship already had. The 2 I have cited, I will give it. And on topic, and on the top, Miller, I'll give the paragraphs also.
Yes.
And
Whose volume is this? Whose book is this? Parabola marker. Yes.
For orders. Item 18.
Processing for our name,
My lord. Sorry. Lordship, as per order dated 2/12/2022, lordship. Of the repetition, lordship. Today, I think
2/12.
2/12/2022, lordship.
Yes, what has happened? Yes, what is your?
Disclaiming
The
regular.
learned judge has asked you to interpret the Supreme Court judgment.
Yes, one.
Have you done it?
Lordship, one simple, one judgment is there, Lordship. If you place that judgment, Lordship, I will submit my view, Lord.
So it has been listed for orders today, is it?
Lordship, earlier, this honorable court had long occasion, lordship, and lastly, while I placed the judgment, my learned friend is, lordship, I have given the copy of the same also in the file, lordship. I think if not, lordship.
But in any ways, today, nothing
Lordship,
lengthy is
lordship,
possible.
any other subject.
Because
to
there is a
only
division
15
bench also.
For 15 and 16 may not be any other day, lordship.
15 of 16 of March.
No, Lordship.
Before that, not possible.
No, this February, if this man Lordship already retired without anything, Lordship, and my learned and others juniors,
All right, Mr. Mazumdar, we
any
understand.
subject to convenience of this honorable court, any
After
day,
2 weeks as a fixed item.
a fixed date may be
Mr.
given
K.
so that
Chaudhary, Learned Council, Mazumdar, Learned
any
Council.
hearing day so that it can be
Also
finished
heard
up.
Mr.
also.
P. Naik, Learned. Standing Council, PWD Assam, preparing for the respondents. Peruse the order dated 2/12/2022 passed by this court. In view of the submissions made at the bar, let this matter be listed for admission again after 2 weeks as a fixed item.
Any other,
Yeah, no, after 2 weeks.
Item 19.
anything, yeah, no.
Because we are giving probably not three judges, one I have not, but I have given. Same line, the
Hearing matters,
May I
Yes.
please your lordship, my lord, in this matter, the petitioner has been transferred, my lord, before completion of 2 years of service, my lord, by the respondent number 3, my lord. We have taken steps on the respondent number 3 by registered post, my lord. The service report is awaited, my lord.
you are for the respond numbers 1 and 2.
Lordship, two. My learned friend is appearing for one.
Is there an interim order here?
Yes, my lord.
Interim in order is there within the same office, Lordship. we have been
Not same
taken.
office, my lord. It is not same office, my lord. Your lordship may peruse the order, my lord. My lord, Annexure 3, page 24 is the order by which the petitioner was placed in the Banekusi Revenue Circle. But in the
No,
interim
what is wrong with the order? Let us see what is the transfer order.
transfer order
Page 25.
25. There is a typographical mistake in the transfer order, my lord. Here, my lord, it is shown that the serial number 2, the petitioner is at serial number 2, my lord. He has been shown to be transferred from Nalbai Revenue Circle, but he was serving in Banekusi Revenue Circle, my lord, not because the order by which he was placed in the Banekusi Revenue Circle, my lord, that is at page 24, my lord, the previous page, my lord. So in the transfer order, one typographical mistake is there. It has been shown wrongly as Nalbai Revenue Circle, my lord.
But within the district of Nalbari
Yes,
itself. also.
yes, it is within the district, my lord, but it is from one place to another, my lord, and it is within a period of 10 months, my lord, before completion of 2 years of service, my lord. And
So how are you affected?
because before completion of 2 years of service, if he has to be transferred, there has to be approval from the chief minister, my lord.
No, that transfer is if it is from one location to another,
Yes, my lord, it is from one location to another.
Hmm.
Banekusi is a,
not in the same district.
it is in the same district, my lord.
And then
But-
otherwise, where is the transfer jurisdiction is only if it adversely affects or violates the service condition or personal life. What is violated here?
Because, my lord,
What is violated here? That's why I'm asking.
violation is, my lord,
It
because,
is more comfortable for him here.
yes, my lord.
We are not concerned with his comfort.
I am not uncomfortable, but it is in the clear violation of the, my lord, office memorandum, my lord.
Office memorandum is not mandatory. There are so many judgments.
Yes, my lord, it is
You
not
also know.
mandatory, but otherwise
Transfer can
also,
be made in one day also.
otherwise also, my lord, if he has been transferred before 2 years, my lord, there has to be some reasoning and justification, my lord. So because of that, the government was asked to produce records, my lord, by the last order, my lord.
Justification from whom? You have records.
Yes, records are called from our office, Lordship. We have not yet received, but if your Lordships kindly come to page 23.
Hmm.
That is the order of reinstatement, Lordship, as because he was suspended because of the pendency of a criminal case. Page 23, last but one paragraph. As a result,
Yes.
the respondent shall forthwith reinstate the petitioner to his post as because 3 months' time has already been elapsed because of this reinstatement. It is, however, made clear that the employer will be at liberty to post the petitioner wherever he want in the exigencies of service as well as this. It is also reflected in the reinstatement order itself. And but not because of this, because of the interest of public service, Lordship. He has been transferred, but within the same district.
It is within the same district, but
Mr. Bora, 5 minutes. After that, I'll dictate the order.
yes, my lord,
Because my only contention is that, my lord, because my lord, he has been posted there only in the month of, my lord, February 2022. So within a period of 10 months only, he has been transferred from that office.
Because of the corruption, sir, FIR law,
No,
he
my
was
No,
arrested.
my lord, no, my lord, that is not established, my lord.
He
because-
was arrested,
because
bail
he was
granted.
arrested in the series of case, my lord, the land mafia, then in that series of cases, my lord. That is not established, my lord. That is not
Yes.
proven, my lord.
FIR was lost. I am stating that FIR was
again,
lost. Bail
because-
granted,
Because.
suspended. As because 3 months' time has already been elapsed, because of that, this
Because
honorable
that
court
time
has
without
directed
there
for
being any-
reinstatement.
Without there being any specific allegation on the basis of a similar design FIR on before the every police station, my lord, the petitioner has been also arrested. In the same process of the my lord, land broker and that case, my lord. The petitioner was arrested, my lord, in connection with the FIR which has been filed in all the districts, my lord. Many other, my lord,
That's all right. We are not
yes,
on
my
that.
lord, that is not established, my lord. That charge is not established, my lord. So he has been suspended, my lord. Subsequently, he has been posted, my lord. Because it is a harassment for him. Because firstly, my lord, because without any specific allegation, he has been arrested. Without there being any specific allegation, he has been arrested. He has been posted in Banekuchi Revenue Circle. So he is serving there. Now, my lord, within a period of 10 months only, again, he has been transferred from there, my lord. He has to be settled somewhere, my lord.
He is transferred from Nalbari Revenue Circle
That
to
is
the
wrong, my
land
lord.
acquisition branch in the
That is
same
wrong.
district.
That is wrong, my lord. That
What
is
is the correct position?
correct position, page 24, my lord. He was in Banekuchi Revenue Circle, not Nalbari Revenue Circle. my
Even
lord.
then, within the
Page-
same district,
Page
Nalbari.
24, my lord.
If we accept it to be wrong, lordship, this Nalbari revenue, so it is under the Nalbari Revenue Circle.
Not under Nalbari.
Mr. Bora, you should go. These are not
Lordship.
matters.
But
It's
my
not for
lord,
writ petition.
because he has been
We
harassed.
interfere in transfer matter where there is something, some grave injustice or personal difficulty faced. We do it, but you have to accept transfer orders. Heard Mr. B.P. Bora, Learned Counsel appearing for the writ petitioner. Also heard Mr. H.K. Sharma, H. Sharma, Learned
Respondent number
Additional
2.
Senior Government Advocate Assam appearing for the respondent number 2. And Mr. S. Dutta, Learned Standing Counsel, Revenue and Disaster Management Department, Assam appearing for the respondent number
One.
1. Full stop. None has appeared for the respondent number 3. This writ petition has been filed by the petitioner assailing the transfer order dated 28/12/2022, by means of which the petitioner, who is presently posted under the Banekuchi Revenue Circle, has been transferred and posted in the land acquisition branch in the district of Nalbari. Full stop. It is to be noted herein that the transfer of the petitioner is from one branch of the district administration to another
No,
within
my lord,
the,
that is not correct, my lord. It is a different place, my lord. Banekuchi Revenue Circle is a different place.
is from one revenue circle to another,
Yes,
but within the same district
Within
of
the-
Nalbari. Full stop. The primary ground to assail the order of transfer is that the order has been issued within a period of 10 months
Yes.
of his posting at the Banekuchi Revenue Circle, and therefore the same was in violation of the transfer guidelines applicable in case of government employees. Mr. Bora submits that no approval of the superior authority was taken before issuing the transfer order before completion of normal tenure of 3 years. Full stop. Responding to the above, Mr. Sharma has pointed out that the petitioner was earlier arrested in connection with Nalbari PS case number 523/2021, registered under sections 120(b) /420/401/407 of the IPC. In view of his arrest, full stop, in view of his arrest, the petitioner was also placed under suspension by order dated 11/10/2021. Full stop. However, subsequently by the order dated 31/1/2022, passed by this court, passed by the learned single judge in WPC number 72 of 2022. The order of suspension has been interfered with and a direction was issued to reinstate the petitioner forthwith, full stop. However, in the order dated 31/1/2022, it has been liberty was granted to the respondents to post the petitioner wherever they want in the exigencies of service. Full stop. Mr. Sharma submits that the impugned transfer order has been issued in exigencies of public service and in terms of the leave granted by the learned single judge. Full stop. Similar is the stand of Mr. Datta. Full stop. It is no doubt correct that there is a policy of the government of Assam not to transfer government servants before the completion of their normal tenure of 3 years at one place of posting without obtaining the approval of the highest authority. Full stop. However, such guideline is not mandatory and has been merely brought into effect to put a halt to arbitrary orders of transfer. Full stop. In the present case, the transfer of the petitioner is within the same district and therefore it does not dislocate his family life in any manner. Disrupt, not dislocate, disrupt his family life in any manner. Moreover, the order of transfer was also apparently issued in terms of the leave granted by this court by order dated 31/1/2022. Having regard to the facts and circumstances of the case in its totality, I am of the view that no case has been made out for interference with the order of transfer by this court. Full stop. The law is well settled that the scope of interfering with an order of law is well settled that transfer is an incident of service and the scope for the writ court to interfere with such order in exercise of jurisdiction under Article 226 is very limited. Full stop. It is only when the order is found to have been issued in mala fide exercise of power or in violation of the conditions of service of the incumbent that an order of transfer is usually interfered with. Full stop. As noted above, there is no such ground either urged or established by the petitioner. Consequently, this writ petition is held to be devoid of any merit. Same is accordingly dismissed. Interim order passed earlier stands vacated. If there is any other problem, come back to us. We'll protect you. Tell your clients that he should join. High Court is not meant to do arm twisting with the revenue, with the district administration. We are not going to promote that. We will protect the rights if they are being violated. Not as a luxury to stop a transfer, move from one place to another. This is not the purpose of writ jurisdiction. Yes, next matter.
Much so.
For hearing partner matter, item 20.
This is the matter where he was accused of being intoxicated in service, the driver, with a smell in his mouth. So she was, the last of the she wanted.
Can he acquire for today if possible, madam, maybe taken tomorrow, madam.
Tomorrow, why don't you do it on Sunday?
No, madam.
Huh? You're not free on Sunday.
No.
You're not coming to court.
Not that.
She's not ready today.
If possible, otherwise, madam.
No, possible. If you want, why not possible?
Tomorrow.
Thursday? Heard Mr. R. Mazumdar, Learned Counsel for the writ petitioner, also heard Ms. A. Gayan, Learned CGC, appearing for the respondents who has made a request to post this matter again on 16/2/2023. Yeah, allowed, please take up.
Madam.
Item 21. Item 21.
Yes,
please.
what is this matter,
Mr.
Mr.?
Sikand's dismissal from service, my lord. He was dismissed in the year 1999, my lord. Thereafter, he had approached the Allahabad court, my lord, which returned, my lord, saying that the jurisdiction is not there. Therefore, he filed this case here, my lord. Basically, my lord, I am complaining of infraction of Rule 27 of the CRPF rules, my lord. He was a constable of the CRPF, my lord. And my lord, pursuant to the department proceeding, my lord, he was dismissed from service. Mr. Sharma, B. Chakraborty, my lord, was there, my lord. It's just here, my lord.
When was he dismissed?
99, my lord. 1911, 99, my lord. Now, only relief perhaps he can get is, my lord, some compensation in the form of back wages if it is set aside, my lord. Otherwise, he is, lord.
Lordship, only one aspect in this case, some records are in Hindi, so courts sought an assistant from an officer who is well versed. He was here in the first step, but Lordship, he went because I told him that it may not. Can it be taken up Tuesday next, Lordship?
No, but if he has come, he should have been here. Tuesday next is not possible. Many, in fact, I can list it, but you will sit for the whole day.
Lordship. Any convenient date to Lordship pleases, Lord.
21st.
21st.
Heard Mr. M. Rattal counsel for the petition. On the request of Mr. B. Chakravarti and CVC, appearing for the respondents, that this matter is listed again for hearing on 21st of February.
Obliged, Lordship. My lord, I'm permitted to make a mention on that day before arbitration of the matter. Within 13 minutes.
22 and 23.
Lordship, this matter, otherwise issue is very small. The respondent who has not complied with the transfer order for he was sent for 1 year only. And the punishment imposed was that he will not be entitled to privileged classes, privileged passes. So simply for that, it was dragging for long. And by this time, he has retired from accepted from his. But he has swear affidavit in that is 54 in 2015. If that is true, then he is 62 by this time, Lordship.
Lordship, let me place the fact, Lordship. Kindly, Lordship, turn to the award. But
No, we'll go to that, but what is under challenge here?
Lordship,
they have challenged the award that central tribunal, they've given on
Central
31.
Tribunal.
Yes.
Award was for his reinstatement.
Who has passed the award?
Award by the
Central Industrial
Central
Tribunal.
Industrial Tribunal. That is page 35.
The award
Because
was for his reinstatement with 50% back wages, but he was not dismissed.
Lordship, I have given a short note to the honorable court.
The issue was to justify whether the transfer was valid or not, justified or not. That was the issue, Lordship,
And the order is for reinstatement.
for his
No,
reinstatement.
not the reinstatement. It is not a termination, not suspension. That is a very peculiar case, Lordship. What happened when the order of transfer order was given? So he refused to the transfer order because in that station there is no upgraded post as per his post. So there he was. So his name was struck out from the register in 2008. And since then he was not allowed to perform duty. He was not allowed to enter the campus. That's why this referred to the Central Industrial Tribunal. Then tribunal, after they have contested the case, Railway has contested the case. They have evidence. Then ultimately, award is given on page 35. The award. Finally, because everything will be clear on the award.
So he was not allowed to work
Yes, not allowed to work.
since 10/7/2008
Okay.
till the date of his retirement, which is the date? His name was struck off from the record, from
Lordship,
the
it's the
register.
normal practice that when person is sent from one place to another, the place where he is working has to be struck out. That is the railway follows, Lordship.
Hmm.
So he was sent there with the post, Lordship. His contention was that there was no sanctioned post there, but he was transferred along with in any case, Lordship, the transfer orders for 1 year only. Simply it is dragging the matter, Lordship.
Correct. No, but why don't you pay him 50%?
Lordship, I think so that will be the proper because he has to get the relief.
Yes.
Otherwise, the punishment was anyway, Lordship, he will be not entitled to privileged passes. That was the punishment imposed.
That is already over.
But-
That punishment has been already over.
Privilege passes.
Passes.
That is all punishment. That punishment
But
is
why
already
he
over.
has not joined, that is his fault. That part is there, Lordship.
So
He has
it-
not
because-
gone on an assumption that no such post exists.
No, there
After
is no
that,
post-
after 1 year, he
in
ought to have
fact,
been reported
In
there.
fact, there was no post, in the findings, kindly Lordship, there, that there was no sanction post. That's why,
No.
not kindly Lordship, Peru this.
When post
That-
was, he was transferred with the post, Lordship. That was the transfer order, Lordship, at page.
And
How can a section engineer be treated as a workman? He's a
Lordship, that is-
workman.
because salary is less in that period.
Where is this place called Murkak Chalan?
In somewhere near not Lakhimpur, Lordship.
No, Mokok Challenge. Transferred to Mokok Challenge from Romia
To place to go.
in the district of Lakhimpur.
It is also. it is.
So because he did not join in that place, disciplinary proceeding was initiated.
And punishment was that he will be not entitled to
His name
privilege.
was struck out from the register.
Otherwise, he ought to be there. After 1 year, he ought to have come and joined their Lordship. So simply a small
Neither
matter has
was-
been dragging for long, Lordship.
But Mr. B. Chakravarti, Learned Counsel appearing for the writ petitioner. I also heard Mr. H. Rahman.
Only
Learned
one
Senior
aspect,
Counsel.
Lordship, the issue was, the reference was for is whether to declare his, anyway, I will give you, Lordship.
Mr. H. Rahman, Learned Senior Counsel, assisted by Miss
P. Agarwal.
Yeah, Lord.
P. Agarwal, Learned Counsel appearing for the writ petitioner. By filing this writ petition, award dated 31/1/2014, passed by the learned Central Government Industrial Tribunal dash com dash Labor Court, comma Guwahati, comma Assam, passed in connection with reference case number 02 of 2011 has been put under challenge. Full stop. The facts of the matter, comma, briefly stated, comma, is to the following effect. Stop. The respondent was serving as a section engineer, bracket SE, bracket close. Then again bracket C and is a symbolic and W, bracket close, Rangia Railway Station. When he was transferred from Rangia to Murkak, MURKAC, Murkak Chalan, CHALLENG, on 24/12/2007. By providing that his pay scale would be rupees 6,500 to rupees 10,500. Full stop. However, That is on
same pay scale, Lordship.
Huh?
It's written in the
Yes.
test per order, page
However,
29.
On the date of such transfer, there was no post of section engineer at Murkak Challenge carrying the pay scale of 6,000 rupees 6,500 to rupees 10,500. Full stop. In view of the above, the petitioner was reluctant to join in this aforesaid post. Full stop. Consequent, however, since there was
Not petitioner,
respondent, huh? However, the name of the respondent was struck off from the attendance register of the Rangia office with effect from 10/7/2008.
As per railways policy, Lordship, that may be.
Thereafter, a memorandum of charge dated 29/10/2007 was served upon him, leading to a disciplinary proceeding against the respondent. Full stop. On conclusion of disciplinary proceeding, penalty of stoppage of two.
That was in different proceeding. That is not a part of this. In this case, he was, penalty was that he will not be entitled to privilege passes. That is the only punishment, Lordship.
No, in this case, memorandum of charge was given
That
to
was,
him.
that's.
Then penalty imposed was,
Only may I correct?
we'll have to hear the matter. Please have another date. I'm rising in 5 minutes. I can't complete it.
Then let's see.
This will take time
What date will be given?
because
Because the award-
either if whole hog, reading the award will take half an hour. There's a division bench.
Lordship. So, so it is a long pending case, lot, let it be, lordship, day after tomorrow or. can we- Oh, sorry.
No, what has happened here? Because he did not go, memorandum of charge was served.
Served.
Then a penalty of,
The two sets of privilege passes was withheld. That is penalty.
Likhok, and subsequently the penalty of withholding of two set of
Yes, two sets of pass.
privilege passes
Yes.
was imposed upon the petitioner. Full stop.
But as because
In
we-
view of the above development,
Hmm.
an industrial dispute arose
Yeah.
between the respondent and the petitioners. Full stop. As such, a reference of the industrial dispute was made
With the following issues, Lordship may quote the issue, Lordship.
by the Ministry of Labor, Government of India, New Delhi, by order number L-41011/122/2010-IR bracket B dash capital Roman 1 bracket close dated 13/1/2011. The schedule of reference is as follows, page 36 of Pabo. Full stop. Upon consideration of the materials available on record and on hearing both the sides, the learned Central Industrial Tribunal had answered the reference in favor of the respondent. And granted the following relief to him. Page number 50, double tick to double tick. Full stop. Assailing the impugned award dated 31/1/2014, Mr. Chakraborty submits that the respondent was transferred only for a period of 1 year along with the post he was holding, and therefore there was no justifiable ground for him to refuse to comply with the transfer order. Full stop. Had the petitioner joined at Murkak
Murokseleng.
Murokseleng.
Murkok selling.
So it is MURKAC.
Hmm.
Spelling to syllabus on page 36.
MURKAC.
He would have been brought back to Rangia within a period of 1 year. Full stop. Mr. Chakravarti, however, submits that the petitioner has since retired from service.
Respondent.
Sorry, the respondent has since retired from service.
Yes, so far my knowledge is not retired, for my knowledge. So far my knowledge, my instruction are not retired.
Then what to do? Then
In
we
any
can-
case, Lordship will be entitled to the monetary bill.
According to Mr. B. Chakravarti, the respondent has already retired from service and therefore save and accept the monetary benefit, no further relief can be granted to him at this stage. Mr. Rahman, and as senior counsel for the respondent, has however strongly refuted such contention and submits that his client is still in service. Full stop. Be that as it may, since the award of the learned tribunal is to pay 50% of the wages of the petitioner with effect from the date on which his name was struck off from the attendance register. That is WF 10/7/2008
10/7/8.
till date,
Till his,
Or
till
till
his
his-
reinstatement.
till his reinstatement. And considering the grounds on which the aforesaid award has been passed, I do not find any justification in interfering with the same. Full stop. Insofar as the controversy regarding retirement of the
That
respondent
will
is
be covered
concerned,
as per service
the
records,
said aspect of the matter would be dealt with as per the
service record. Lord.
entries made in the service book. Full stop. However, it is made clear that the amount payable to the petitioner as under the award dated so and so shall be calculated with effect from,
Date of judge, date of award. Lordship.
with effect from, no, whatever,
No.
10/7/2008
10/7/2008.
till the date of his retirement, if the petitioner is in the meantime retired from service, or till the date of, or otherwise,
Reinstatement.
till the date of his reinstatement. Full stop. With the above observation, this writ petition stands, two writ petitions are there.
One filed by the.
Next petition we have filed because we are not allowed to join after the award. But railway has filed this petition, that's why.
In view of the order passed,
So,
That is WPC 150 disposed of.
in view of the order passed.
In view of order passed in WPC 1520, WPC 824 of 2015 also stands.
One thing may be made clear because due to pendency of this case, 6th pay commission, 7th commission, no benefits given.
All he can claim, Lordship. All he
At-
can-
Those things we can't go into.
At least 6th pay commission benefit,
Let him. claim.
other benefits because we pay.
Then we'll have to hear the matter. It'll be a half a day exercise.
But-
Because then you have to argue. Just at the end, give me this, give me that. You can't do that.
No, but it is.
You want to argue the matter whole,
No, because normally he is entitled for the revised pay.
that they will give you. If they don't give you, then you have to come to the court.
Because.
I can't just add 2 lines in the bottom to give him this and that and that.
No.
Nothing beyond what the award has been given. That is the subject matter of this proceeding. All right,
Right.
all right. Okay, that's all. 26, decide on a date in March.
Yes, my lord. Here
Tell
also,
the
my
date.
lord, the private respondent, my lord, he is not allowed to join. And award is in his favor, and he was allowed to be reinstated with back wages. That was not done, and he is at present his
So
jobless.
you decide on a date.
Yes, lordship may kindly give a short date as permitted.
Tomorrow,
Tomorrow, yes, lordship.
but the matter will not be heard tomorrow also.
Then lordship, any convenient date, my lord, when there is.
You take a date, any date in February, the matter will not be heard, but you will have to sit here. So there are 30, 40 cases already posted on each hearing day. You can take a date.
Lordship will just discuss and take. the-
Yeah, we discuss. in-
Whenever there is less cases, lordship in March.
We don't have any problem in giving you a date. But you will have to come and sit, keep sitting for the whole day. If you want to do that, no problem.
Lordship.
Understand the
I'm
urgency.
also standing pro bono, my lord, for the respondent, my lord, because his condition is not that good.
No, we understand, but then take it on 16th, we'll see.
16th, my lord.
Any other? So we'll write
Applies,
down.
my lord.
Take the division bench now. we have allowed the appeal, set aside the judgment and laid some guidelines. The reasons why we have set aside, we have mentioned. This was a mini trial held and the court went into question of possibility of conviction rather than grounds to proceed. And we held that there was a violation of principles of natural justice. On certain points, the prosecution was entitled to an opportunity. So let him give it day-to-day hearing. Those who on bail to remain on previous bail.
My lord, there is one difficulty. Appellant, sorry, respondent in the first appeal, he is not on bail, my lord.
We have said that if he moves the bail application.
Yes.
And the direction is to appear on 23rd of February. Not before that. And if he files a bail application, it will be considered on its own merit, on fresh reasonings and without being influenced by anything. Right. But the exercise needs to be done again. And you go through the judgment we have discussed. Of course, in these matters, it is very difficult to lay down very strict parameter. But we had a feeling that the order has a trappings of an order of acquittal rather than order framing charge. Could be debatable issue, it can be tested. Yes.
Diploma.
Yes.